Very good morning. Am I audible to everybody? Ladies and gentlemen, thank you once again for inviting me to the Judicial Academy. Like the proverbial bad penny, I have turned up once again. But at the very outset, let me wish all of you good tidings on our behalf for completing 50 years and your Golden Jubilee celebrations. It's been exactly 50 years and 15 days. But I do believe, on a personal note, that rather than India, it is actually the Indian citizens who have gained. And it is the Indian citizens and India as a country that is privileged to have Sikkim as a part of its body politic. Because apart from being the most beautiful state in India, the citizens of this state are perhaps the most polite, well-mannered, affectionate and friendly people that I've seen anywhere in the country. And it's a privilege and an honor to come back to your lovely state. And I express my deep gratitude to the director for having me once again. The topic for today's deliberation is the Arbitration and Conciliation Act 1996. Now, to talk about the Arbitration and Conciliation Act 1996, one always talks about this proverbial joke where there is this science congress and we have the host country, we have England and we have India. So the host country produces an infinitesimally small pipe or a rod which can't even be seen with the naked eye. It's so tiny, it's so narrow, it's so fine that one has to see it with a microscope. So the host country gives it to the two countries participating and says, come back and tell me what you can do with it. The next day the English team come forward and gives the rod back. The host country asks, what have you done with it? So the English team says, look under the microscope, you will find that I have converted the rod into a cylinder by drilling a hole right through it. This seems to be something which cannot be bettered. The Indian team says, don't worry, I'll come back tomorrow and better this. So next day the Indian team comes back and the host team says, what have you done? It seems to be the same thing. The Indian team tells the host country, look deeply, look through your best microscope and you will see what we have done. And lo and behold, when the same cylinder was looked at, it was found that inside was written, made in India. This is really the story of the Arbitration and Conciliation Act 1996. On the 21st of June 1985, the United Nations Commission on International Trade Law adopted the model law. The General Assembly of the United Nations recommended that all its member states should adopt this so that there is uniformity in the procedures in arbitral proceedings throughout the globe. From 1985, it took us till 1996. In August 1996, English law and the Indian law came out. If you have a look at the English Arbitration Act 1996, you will find that the English were careful to adopt the model law according to its own requirements, its own needs, its own peculiarities, the systemic practices in their country. But what we did was, we followed the ancestral model law, making minor changes, which is why from 1996 to 2025, we've had to make 3 major amendments. In 2015, in 2019, and in 2021. When we were growing up and we studied law and we started practice, we had the 1940 Act, the Arbitration Act 1940. When the 1996 Act came in, we had to unlearn everything and study the 1996 Act. And with judgments coming in and amendments coming in, every day we had to learn and unlearn. And if I may say so with great humility, the only thing certain about the arbitration law is its uncertainty. The only thing constant about the arbitration law in India is the lack of its constancy. Let me start with an illustration before going into depth into the law. Let's go into the provisions for appointment of an arbitrator. Provisions for appointment of an arbitrator are relegated to the Chief Justice or the High Court. But just to have a bird's eye view of what the provision is, Section 11 of the Arbitration and Conciliation initially said that the appointment of the arbitrator, if the parties cannot agree in their agreements, or if the mechanism for appointment of an arbitrator fails, would be by the Chief Justice. The question arose, is this power which is conferred on the Chief Justice an administrative power or is it a judicial power? Because Section 11 said Chief Justice. The Section 11 then in 1996 Act said when a request is made to the Chief Justice. So the Supreme Court construed that and said it's a request to the Chief Justice, not an application before a court. So it is really an administrative power. The Chief Justice does not need to decide anything. This gave rise to a lot of hue and cry all over the country. Several matters went up to the Supreme Court until a larger bench was constituted. And then the Supreme Court said that it is impossible to believe that the Chief Justice of the High Courts or the Chief Justice of the Supreme Court in case of international commercial arbitrations would act as a rubber stamp. It's inconceivable. The power must be judicial. So from administrative, it went to judicial. Then came another batch of matters when the Supreme Court said by saying it is judicial, we are really abrogating the powers of the arbitral tribunal unto ourselves, because there is already a provision under Section 16 of the Arbitration and Conciliation Act where the arbitrator himself has the power to decide questions of existence, jurisdiction, etc., validity of an arbitration agreement. So no, the power of the Chief Justice for appointment is only administrative. So we came back to square one. Ultimately, all this led to a Constitution Bench judgment. And in the Constitution Bench judgment, ultimately the Supreme Court decided, no, it has to be an adjudicatory power. Not only is it an adjudicatory power, but this decision by us that this is going to be adjudication and not a mere administrative order is effective from today. So previous appointments will not be affected. Secondly, the Supreme Court said that this power will not be delegated from the High Courts to the District Courts, and it will remain only with the High Courts. So far so good. So we had administrative to judicial to administrative, then the Constitution Bench saying judicial. Then came another judgment, Bogara Polyfab, which said no, hang on. We will lay down what in Section 11 the courts must decide, what they can decide, and what they should not decide. So tests were laid down, saying that these are the aspects which the Chief Justice must decide. These are aspects which Chief Justice may or may not decide. If it decides it, that's the end of the matter. If it does not decide it, the arbitrator will decide it. And if it does not decide it, then the arbitrator has absolute power. In the meantime, 2015 amendment came in. In 2015 amendment, realizing the difficulties that the words request and Chief Justice was creating, they changed request into application. the Parliament changed request into application and Chief Justice into the High Court. So it became an application to the High Court. And in terms of the judgment of the Supreme Court, mandatory issues which the Section 11 Court had to decide was whether there was an arbitration agreement, whether the parties to the application were parties to the arbitration agreement, and whether there were arbitrable disputes. Then what was it that they could or they could not decide? For example, question of limitation. The Supreme Court said if it was apparent on the face of the record that it is dead wood, nothing remains, then you can decide it. But if it's a mixed question of law, then leave it to the arbitral tribunal. So these are aspects which they may or may not decide. And what could the Section 11 Court not decide at all? Say question of accord and satisfaction. Whether there has been discharge of the liabilities of the parties by full and final settlement. These would be relegated entirely to the arbitral tribunal. So from one side of the spectrum to another side of the spectrum, the pendulum kept swinging. This judgment of Bogara qualified, we said these are the tests. So in that and by that time we were as lawyers sanguine that this is actually what the law is. But then hold, came an amendment to the statute and section 11(6) capital A was inserted. And in section 11(6) capital A, the legislature said that the court, while deciding an application under section 11, will not do anything except go into examination of the existence of the arbitration agreement. So we went back to the original position that we were nothing but a post office. By legislative amendment, the powers of the High Court and of the Chief Justice of the High Court or the judge taking arbitration matters was curtailed, so that now the law became the powers of the High Court were restricted only to examination of the physical existence of the arbitration agreement. Then the legislature realized that something was going wrong. So then they issued a notification saying that section 11(6)(a) is repealed. Unfortunately, this repeal act was not, this repeal act was part of a notification. The notification said that the notification will come into effect on the days that the specific sections are notified. And section 11(6)(a) repeal was never notified. So despite, if you see your bare acts, if you have your bare acts, you'll find in section 11(6)(a) there is a third bracket which says omitted by amendment such and such. If you have a look at section 11(6)(a), it says omitted by the Arbitration and Conciliation Amendment Act 2019. Earlier it was inserted by Act number 3 of 2016 with effect from 23rd October 2015. So 23rd October 2015 they inserted it. 9th August 2019 they omitted it, but they omitted to notify this amendment. So if you go by the Bare Act, what you will know is the wrong law, because the omission has really not been notified. So 6A continues on the statute books. And even now, the powers of the High Court while appointing an arbitrator are restricted only to seeing the existence of the arbitration agreement. They cannot go into any disputed questions of fact. So what does one understand of arbitration today? What I see today may not be the law tomorrow. And again, maybe the law day after tomorrow. That is what it seems if one goes through different provisions of the Arbitration and Conciliation Act 1996. So if anybody asks me which is the best book, the best textbook on arbitration, I can only look back him and say buy a Bare Act and be aware of the notifications, because you really don't know what the law is. This is just on section 11, the power of the court to appoint an arbitrator, and that has changed so many times in these few years. So really speaking, as judicial officers, if you ask me a question, I would rather say please pass your order and please tell me the name of the losing party, I will assist him in the appellate court. Because nobody knows what the correct law is till it goes up to the Supreme Court. All down right from 1996 right till end of April 2025, we knew that an arbitral award cannot be touched by a court which is setting aside an arbitral award. An arbitral award is set aside in terms of the provisions of Section 34 of the Arbitration and Conciliation Act. I'm sure all of you have had chance to deal with Section 34. The law as we understood was that in Section 34 proceedings, the court could either sustain the award or set aside the award. This was the limit of the court's power. The 1940 Act contained a provision under which the court could remit the award back or could modify the award. 1996 Act did not have these provisions. So your duty was either sustain or set aside. In April, the constitutional bench of the Supreme Court says, no, you can modify. I end my discussion ultimately with this judgment, where a constitutional bench in 4:1 verdict says you can modify the arbitral award. In Section 34, if portions of the award are severable, then in Section 34 court can modify. So the entire thing that we knew as a lawyer or as a judge about what is arbitration is undergoing drastic transformations every day. So with this background and with this caveat, may I go into a short expose on what, according to me, is the current position so far as different important facets of the Arbitration and Conciliation Act is concerned. I'm not sure how well this will work or how much visible this is, but when we started in 1996, we really had 4 parts. Part 1 was domestic arbitrations, sections 1 to section 43, which is something we will deal with today. Part 2 was enforcement of foreign awards. There were 2 types of foreign awards which are enforceable. One is the New York Convention Awards, the other is the Geneva Convention Awards. Part 3 was conciliation, that's section 61 to 81. And part 4 supplementary provisions. Then in 2019, the legislature thought it fit to introduce several amendments. One of the amendments was to constitute the Arbitration Council of India by way of introducing Part 1A. Part 1A consisted of sections 43 capital A to 43 capital M. Now again look at the vagaries. Section 43B required the central government to issue a notification to constitute this council. This notification has not been issued till today. So Part 1A is a dead chapter really. It's not effective, it has not seen the light of the day. So we are now still having Part 1, Part 2, Part 3 and Part 4. We will deal primarily with Part 1. Part 4 is essential because there is an important provision there, that is repeals and savings. Because when 1996 Act came into force, there were several statutes which were already in force. There was one with regard to domestic arbitration, the Arbitration Act 1940, and 2 statutes with regard to foreign arbitrations. So we had Section 85, the repeals and savings section. Now the provision of the repeals clause in Section 85 is essentially that it recognizes that there may have been thousands of arbitrations which had already commenced prior to 1996 and which were underway. Now insofar as these arbitrations were concerned, they would all continue under the old Act, that is the 1940 Act. Unless the parties contracted out of statute. This was again an exception being created, because one usually knows that a party is not permitted to contract out of statute. But here the legislature recognized the right of the parties to contract out of the statute and say no, despite the Arbitration Act 1940 being applicable to us, we will henceforth be governed by the 1996 Act. So this liberty was given to the parties. And you will find that in subsection 2A, which says that notwithstanding the repeal, the provisions of the earlier enactments, they would apply in relation to arbitral proceedings which commenced before this act came into force unless otherwise agreed by the parties. So this is an important part of the 1996 Act. The other important feature is in clause B of subsection 2, that all rules and notifications under the earlier enactments, unless there was something repugnant, they would continue as if they were under the new Act. So this is how the new Act commenced. The next important question really is, what is arbitration? And what is the difference between a court and an arbitral tribunal? Appears to be very basic. The first question which was striking you is, why am I asking this question before this august house, which is actually dealing with cases on a day-to-day basis? But the question did arise in the Supreme Court. And I have forwarded a bunch of judgments for consideration. The first judgment in that list, Paramjit Singh Patheja versus ICS Limited, 2006-13 SEC 322, deals with this aspect. Very interesting matter. This gentleman, Patheja, Paramjit Singh Patheja, was a guarantor in respect of loans availed from ICDS. The company, his company, availed of these loans. The company fell into debt. ICDS instituted proceedings against the company, making him a respondent as the guarantor, and an award was passed. On the basis of this award, the creditor, ICDS, instituted proceedings under the Presidency Towns, under the Presidency Towns Insolvency Act. Now, one of the provisions of this act was that if there was a decree or an order, that could be deemed to be an act of insolvency of the company. In other words, an insolvency notice could be issued if there was a decree or an order against a corporate debtor. Question arose in this context, is the award of an arbitral tribunal a decree? In other words, does an arbitral tribunal have the requisites and the character of a court enabling it to pass a decree? There's a lot of confusion on this, and the confusion is really because of section 36 of the Act. I'll be running from one chapter and one section to another section so that the entire discussion is done harmoniously. If you have the bare Act, if you have a look at section 36 of the Act, you will see what the confusion is about. Section 36 relates to enforcement of an award. And the provision with regard to enforcement of an award is in section 36, subsection 1. It says that when the time for making an application to set aside the arbitral award under section 34 has expired, then, subject to the provisions of subsection 2, such award shall be enforced in accordance with the provisions of the Code of Civil Procedure, in the same manner as if it were a decree of the court. Under the Code of Civil Procedure, execution is under Order 21. Order 21 has powers of enforcement by way of injunction, receiver, civil imprisonment, attachment, sale, etc. And it says you execute it as if it were a decree of the civil court. So the understanding is that the award operates as a decree. It appeared to be fairly simple. Supreme Court says no. Have a look at these words as if it were a decree. In other words, a legal fiction is being used. And when the words as if are used, Supreme Court says it is not a decree, but only and solely for the purposes of enforcement, it is to be treated as if it were a decree. So for any other purpose, it is not a decree, and it is not to be equated with a decree, except for the purposes of execution in terms of Order 21. Then what is this arbitral proceedings? In this judgment, there's very nice clarification of what is arbitration, what is the difference between a court and a tribunal, and what is a decree and an award. Now, so far as the dispensation of justice is concerned, insofar as India is concerned, we have a system of dispensation of justice set up by the sovereign. And a hierarchy of courts with its procedure, which is designed by the sovereign and takes a litigant from one hierarchy of courts to another, with its rigors of technicalities like the Evidence Act, which is now of course the BSA, the Civil Procedure Code, etc. But the parties have the right to say that we will extricate ourselves out of the system of dispensation of justice set up by the sovereign. Either for the purposes of saving money, which it really does not, or saving time, which also nowadays it does not, or to come out of the rigors of technicalities. Let us have our disputes decided by a domestic forum, by a person in whom we have faith. So the parties go before that person. He may be a lawyer, he may be a retired judge, he may be a technical person, and they get an adjudication. That adjudication is an award. But getting an award is just like putting up a certificate on the wall. You need to enforce it. How do you enforce it? The arbitrator has neither the mechanism, nor the powers, nor the wherewithal. He does not have enforcement powers like a court would have through the police, or through the bailiff, or the sheriff. So the legislature says you can have the adjudication done by a person of your choice, but for enforcement you have to come back to the civil courts. And in the civil courts, there is no decree. So you need to come back and have it enforced in the same manner as if it were a decree. And this is this judgment which delineates the distinction between an award and a decree, a court and a tribunal. This judgment, reported in 2006, volume 13, Supreme Court cases 322. 2006, volume 13, Supreme Court cases 322, which I have forwarded, the PDF of which I have forwarded to all the parties. So this is one aspect. Now that we have got this under control, the question is, what can be referred to arbitration? This is, I set out the relevant portions from the judgment. The expression court denotes a tribunal constituted by the state as a part of the ordinary hierarchy of courts, which are invested with the state's inherent judicial powers. I've explained what the distinction between the court and the tribunal is. Then we have what are the requisites of an arbitration agreement. The most basic criteria for a court before whom an application comes for determination, and an application may come for determination or adjudication under various provisions of the Act. The various provisions are all in Part 1. They are either under Section 9, which is for interim measures of protection, or under Section 14 for determination whether the mandate has to be terminated or not, or it can be under Section 27 for appointment of, for the production of witnesses or documents. It can be under Section 31 capital A for determination of costs. It can be under Section 34 for setting aside an arbitral tribunal. It can be under Section 29 capital A for enlargement of time for making the award. Or it can be under Section 37 appeal provisions. So for all of this, we need to know whether there is an arbitration agreement between the parties. And this is one of the vexed questions which usually arises at the very outset in an application. Now, insofar as an arbitration agreement is concerned, it is defined in Section 7 of the Act. Section 7 has several subsections. I may ignore Section 7 subsection 1 because that really explains what an arbitration agreement is, which is known to all of you. That is, an agreement to submit to arbitration all or certain disputes which have arisen or may arise. So it is not merely, if I may say so, a right to sue. Insofar as civil suits are concerned, what the court sees is whether there is a cause of action. In other words, a right to sue. But in arbitrations, one needs to go a step further, whether there is a dispute. In other words, whether there is an assertion of a legal right and whether that is followed by repudiation. So one party asserts, the other party repudiates, and then there is an arbitrable dispute. A question usually arises, suppose I assert my right to a sum of money. The other side keeps silent. Is that a dispute under which a court can intervene by way of section 9, etc.? If there is a simple request or a simple, if there is simple existence of a right to recover payment and there is silence and no denial, then the court says this is not a dispute. But if I assert by a notice under section 21 or under section 11 saying that such and such amount is payable to me, and the other side either denies it or does not respond, then the silence is treated as repudiation of a right, and that gives rise to a right to file an application. So it has to be an assertion of a right and a repudiation. This question becomes very important sometimes in partnership actions, because despite there being a cause of action, the parties may still be negotiating between themselves, or in commercial disputes between a contractor and employer, where parties are negotiating. There the Supreme Court says that the process of negotiation is a part of this process, and when the final cut-off takes place, when you can ascertain as an officer of court that the negotiations have stood cut off, that is when the dispute arises. This question arises very often with regard to the issue of limitation. Unlike suits where the limitation starts from the date when your cause of action arises, insofar as arbitration is concerned, there are two limitations. One is limitation insofar as the claim, and the other is limitation for making an application for appointment of an arbitrator. And the limitation for making an application for appointment of arbitrator arises only when there is a dispute, when the negotiation ultimately fails. Now coming back to section 7, two issues that I would like to put before this forum. One, please see section 7 and tell me, does an arbitration agreement require the parties to sign it? Does an arbitration agreement require that both parties or 3 parties or 5 parties to have an agreement in signing, an agreement which is signed? And my second question is, while you mull over this, is suppose there is one agreement which has an arbitration clause or does not have an arbitration clause, and there is a second agreement which has an arbitration clause. There are two agreements, A and B. A has an arbitration clause, B does not have an arbitration clause. The agreement which does not have an arbitration clause says all the terms and conditions of A agreement will stand incorporated in B agreement. Does the arbitration clause also get incorporated? The first question is, does an arbitration agreement require the parties to sign it? Ma'am, you will not find the word only. Now what the law is, let me just go into this. The arbitration agreement subsection 3 says it shall be in writing. That's it. Now in court, how do you prove that there is an arbitration agreement? The mere fact that it is in writing is enough. Now how do you prove that such an agreement exists? There can be several ways in which you can prove it. One of which is if there is a document signed by the parties. But there are other means by which you can prove it. That's B, exchange of letters, telex, telegrams, or other means of communication, including communication through electronic means, that's by emails, which provides a record of the agreement. No signature here. So if you can prove that there is an exchange of letters, or there is telex, or telegrams, or emails, or WhatsApp messages, which have a record, there is still the existence of an arbitration agreement, although there is no document which is signed. The third one is even more critical. There is no agreement, no exchange of letters, emails, WhatsApps, faxes, nothing at all. But in my statement of claim, I make an assertion that there is an arbitration agreement. The respondent does not refute that in their statement of defense. So an arbitration agreement comes into being by legal fiction. That's C. An exchange of statements of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other. So one of the issues that we find lawyers raising in courts is that, see, the agreement is not signed. You will find arbitration agreements are part of the laundry bill. You will find, if you go into a hotel, the parking ticket which you will get from the parking valet has an arbitration clause on it. None of these are signed. If you go into a hotel and you buy certain things from a shop, you'll find an arbitration clause on your voucher. They're not signed. The signature is only one of the ways of proving the existence of an arbitration agreement and nothing more. So this is one of the fallacies that is usually misunderstood insofar as an arbitration agreement is concerned. It is mandatory that it must be in writing. Under our Contract Act, a contract is not required to be in agreement. A contract is not required to be in writing. There are certain contracts which have to be in writing. Like a partnership agreement has to be in writing. A normal sale of goods doesn't require writing. It can be by an oral agreement also. But an arbitration agreement has to be in writing, that's mandatory. My second question, Agreement A, which is a commercial transaction, commercial document, has an arbitration clause. Agreement B, maybe a later agreement or an earlier agreement, does not have an arbitration clause. But Agreement B says that all the terms and conditions of Agreement A will be applicable to Agreement B. Let's say today we have a development agreement, giving an example, a development agreement or an agreement for sale, where there are several terms and conditions and there is an arbitration clause. After a while, parties decide to have another agreement where there is no arbitration clause. But this later agreement says that all the clauses, all the terms and conditions of the first agreement will stand incorporated in the second agreement. And the dispute arises under the second agreement. Now, as judicial officers, you will have to first decide whether there is an arbitration agreement. Is the arbitration agreement in the first agreement incorporated by reference in the second agreement? That is the question. Intriguing question. And the answer is in subsection 5. Subsection 5 says the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if A, the contract is in writing, in this case it is, and B, the reference is such as to make that arbitration clause part of the contract. So the second document, when it incorporates terms from the first document, if it does not say anything more, Supreme Court says it only incorporates the commercial terms. To incorporate the arbitration clause as part of the document, it must say so specifically. It must say that the arbitration clause also stands incorporated. Otherwise, the second agreement is bereft of an arbitration clause, and disputes under the second agreement are not arbitrable. So this is again something which comes up very often because we have multiple contracts, whether in a construction contract or engineering contract, a financing contract, development contract. We have a number of contracts one after the other over a period of time. And usually people forget that what they are incorporating are only the financial terms and not the arbitration clause. And mistakenly they invoke the arbitration clause in respect of the last or the final agreement, without there being an incorporation clause which incorporates the arbitration clause specifically. So this is something which I thought was very important to note. Now let us have a look at this illustration that I have put here. Is it readable to all? Please tell me whether this is a valid arbitration clause or not. This is from a judgment of the Supreme Court. If during the continuance of the partnership or at any time afterwards any dispute touching the partnership arises between the partners, the same shall be mutually decided by the partners or shall be referred for arbitration if the parties so determine. It's in writing. We know who the parties are. The disputes will be governed by the arbitration clause if it is a part of the partnership action. Then is it an arbitration clause or not? The answer is no. Why is it no? Because there is no certainty. If the dispute arises, the same shall be mutually decided by the partners or shall be referred for arbitration if the parties so determine. So at the point of time when the dispute arises, there is no certainty that there will be a reference to arbitration. There is a possibility, but no certainty. One of the main requisites of an arbitration clause is that there must be certainty. A clause where there is no certainty is void. The arbitration clause must be unequivocal and unambiguous. Likewise, if I were to modify this clause and say the same shall be referred to arbitration, then it would be a valid arbitration agreement. Instead of saying shall be mutually decided by the partners or shall be referred to arbitration. So if I delete the discretion vested in the parties to refer or not to refer, then it becomes a valid arbitration agreement. Again, if I were to modify this agreement, this clause, and instead of shall, I put in the word may, and say, if during the continuance of the partnership or at any time afterwards, any dispute touching the partnership arises between the partners, the same may be referred for arbitration. Would it be an arbitration clause? No, because there is no certainty. A discretion is given to the parties. This clause fell for consideration in the judgment of 2007, Volume 5, Supreme Court Cases 719. I will not read this portion. I've extracted the portion which is relevant, which says why this is not a valid arbitration clause. So when an action comes before a judicial officer, this is the first thing that one must decide, irrespective of whether the parties raise it or not. Is there a valid arbitration agreement before me? Once it is decided that there is a valid arbitration agreement, the second thing to be decided is, are the parties before me parties to the arbitration agreement? Are the parties who have come before me by way of the petitioner and the respondent, or respondents and petitioners, all parties to the arbitration agreement? And whether the causes of action which have been pleaded in their petition, all subject matter of the arbitration. What happens if there is a petitioner and there are 5 respondents? of which the last two, respond numbers 4 and 5, are not parties to the arbitration agreement. Again, what happens in a petition if there are 5 causes of action pleaded, of which 3 causes of action or 3 reliefs claimed are outside the purview of the arbitration clause? Would still the court take up the matter in its arbitration jurisdiction? This question also came up for consideration before the Supreme Court. And the Supreme Court held that the Arbitration Act does not have any mechanism for bifurcation of the parties between who are parties to the arbitration agreement and who are non-parties to the arbitration agreement. Again, there is no system in the arbitration law for segregating what are causes of action covered by the arbitration agreement, what are causes of action not covered by the arbitration agreement. So in those cases, a reference cannot be made to arbitration and an arbitration court cannot intervene. Let me give an example. A and B enter into an agreement for sale. After that, B enters into an agreement for sale with C in respect of the very same property. Now A comes to know that this very same property has now been sold. The lecture must have been going quite badly. If it's alright, I can continue.
Yes, sir.
Lord is gracious. It's not a reflection of the lecture, it's a reflection of the fingerprints. A and B enter into agreement with regard to a property. B and C enter into an agreement with regard to the very same property. A comes to know that my property is now litigated with a third party. The agreement between A and B has an arbitration clause, the agreement for sale. Now he files a suit saying that I need remedies by way of declaration, injunction, cancellation with regard to the agreement between B and C. B comes and says, no, there is an arbitration agreement between A and B. Suit is not maintainable, please refer the parties to arbitration. In this situation, the court cannot bifurcate between B and C and say the cause of action between A and B will be arbitrable, cause of action between A and C non-arbitrable. We will continue a suit in respect of one part and refer the parties to arbitration in respect of the other part. So whenever the question comes up of bifurcation of causes of action and bifurcation of parties, the arbitration court no longer retains its competence. So far as this is concerned, this came up for consideration before the Supreme Court in a judgment known as Sukanya Holdings. Now, after this, the Sukanya Holdings judgment is reported in 2003, volume 5, SCC 531. It's Sukanya Holdings Private Limited versus Jayesh H. Pandya, 2003, volume 5, Supreme Court Cases 531. The judgment laying down that bifurcation of parties and bifurcation of causes of action is not recognized under the arbitration law. So the arbitration court would have jurisdiction to entertain an application only if all the parties are parties to the arbitration agreement and all the causes of action are covered by the ambit of the arbitration clause. Now there is a rider here. The rider is that if a party to an arbitration agreement is a company, the Supreme Court now says that group companies or related parties, if they are subject to the same transaction, they would also be covered by the arbitration clause. Because if you lift the corporate veil, they are really one and the same entity. So this is the second aspect of the matter. First is there an arbitration agreement valid and binding between the parties? Secondly, who are the parties and what are the causes of action? The third primary issue which the court would decide when an action comes before it is whether the cause of action which is pleaded an arbitrable dispute. The issue of whether the dispute being arbitrable is of primary importance, because it may appear that the subject matter is covered by the arbitration agreement. The parties are parties to the arbitration agreement. There is a valid arbitration clause, but is the dispute which is before me an arbitrable dispute? This question came up for consideration on repeated occasions before the Supreme Court, but the first major judgment on this was when a question came up as to whether enforcement of a mortgage is an arbitrable dispute. Now in this case, SBI Home Finance Limited initiated proceedings against its constituents, including seeking enforcement of mortgage. The question arose before the Supreme Court is whether an action for enforcement of a mortgage where the loan documents contain an arbitration clause, is it arbitrable? Can an arbitration court intervene and grant measures of protection or other things? And the Supreme Court in this judgment has laid down several tests as to when is an arbitration is a subject matter arbitrable and when is the subject matter not arbitrable. I'll just give you a few examples before I come to this example. Suppose there's a criminal offense governed by the Indian Penal Code and its present avatar. Would it be an arbitrable dispute? No. Answer is obvious, because it has special rights and liabilities, the provision for prosecution, provision for fine governed by special statute, which is the earlier criminal procedure code. Let's think about matrimonial disputes. Divorce, judicial separation, restitution of conjugal rights. Suppose there's an agreement between the husband and the wife. Would they override the marriage laws? Obviously no. What about insolvency matters? We have the Insolvency and Bankruptcy Code. Suppose there's an arbitration clause, would they override? Answer is no. So the law always recognized that there are classes of litigations, classes of subject matters of disputes which are not arbitrable. But the first real attempt to classify them was in this judgment, which is known as Booz, Allen and Hamilton versus SBI Home Finance, which in this matter, relatable to enforcement for mortgage, laid down there are real three facets which the court must consider when an application comes before it. The citation is 2011, volume 5, SCC 532. 2011, volume 5, Supreme Court cases 532. Three facets. One is whether the disputes are capable of adjudication and settlement by arbitration. The second is whether the disputes are covered by the arbitration agreement. And the third is whether the parties have referred the disputes to arbitration. We are on the first issue, whether the disputes are capable of arbitration and settlement by arbitration. And as I've noted below, the issue under consideration was whether a mortgage suit gives rise to an arbitrable dispute. While deciding this aspect, the court laid down these illustrations. 6 illustrations. 1. Disputes relating to rights and liabilities which give rise to and arise out of criminal offences. They are non-arbitrable. Secondly, matrimonial disputes relating to divorce, judicial separation, restitution of conjugal rights and child custody, non-arbitrable. Thirdly, guardianship matters, non-arbitrable. Fourthly, insolvency and winding up matters, non-arbitrable. Fifth, testamentary matters, grant of probate, letters of administration, succession certificates, non-arbitrable. And finally, eviction or tenancy matters governed by special statutes, where the tenant enjoys statutory protection against eviction, and only the specified courts are conferred jurisdiction to grant eviction or decide the disputes. These are all non-arbitrable disputes. Now, coming to the question as to whether a mortgage suit relates to an arbitrable dispute or not, the court said, what is that which distinguishes arbitrable disputes from non-arbitrable disputes? Apart from the fact that there may be special statutes relating to certain issues which may make it non-arbitrable. What the court must consider, whether it is a right in rem or a right in personam. If you are deciding any action which has its effect on people other than the two parties to the litigation, it is the right in rem. But if it is limited to the two litigating parties alone and does not have repercussions on anything else or anybody else, it's a right in personam. Matters which decide rights in rem are non-arbitrable. A mortgage suit decides rights vis-a-vis not only the mortgagee and the mortgager, but also there's a right of redemption, right of equity on the clause of redemption, and there are third-party rights involved. Therefore, a right to enforce a mortgage is non-arbitrable. Special provisions are contained in the Civil Procedure Code in Order 34 with regard to mortgage suits. So the Supreme Court decided that an action for enforcement of a mortgage is non-arbitrable. If you have copies of this judgment, you will find that this aspect has been dealt with at length with regard to judgments in rem and judgments in personam, as well as these illustrations. There was a dispute which arose later on the question which you will find in the sixth illustration: eviction or tenancy matters governed by special statutes. For example, in West Bengal, we have the West Bengal Premises Tenancy Act. The central law, which is the Transfer of Property Act, is also applicable. Now, the West Bengal Premises Tenancy Act says that these are the types of tenancies which will be governed only by these special statutes. So, if you look at C, if a particular action by a landlord or a tenant fell within the bounds of the West Bengal Premises Tenancy Act, because it's a special statute, it's non-arbitrable. But what would happen if it is outside the scope of the special statute? In Sikkim, I'm sure you also have special statutes with regard to rent control legislation. What happens if it is outside the scope of the special legislation? This question came up for consideration before the Supreme Court. And here the Supreme Court actually gave a judgment initially which said no, that even provisions of the rights and liabilities of the tenants and the landlords which are governed by the Transfer of Property Act would be non-arbitrable. Because the Transfer of Property Act has special provisions, 106, 111, etc., with regard to how leases are to be determined and what proceedings are to take place. This matter created controversy because it was a question of a general law and not a special statute. And the matter went before a larger bench of the Supreme Court, a bench of 3 honorable judges. And that is a judgment of Vidya Droria, which ultimately decided this matter, a judgment of 3 honorable judges in 2021, volume 2, SEC, page 1. The question which was referred to the larger bench was specifically whether if an issue arises under the Transfer of Property Act and not under a special state statute with regard to eviction matters or tenancy matters, would it be arbitrable or non-arbitrable? (2021) volume 2, SEC, page 1, a judgment of 3 honorable judges of the Supreme Court. In fact, 2 of the judges of this bench later became Chief Justice of India, Justice Ramanna and Justice Sanjeev Khanna. Now, in this case, ultimately it was decided that if it is a matter relating to Transfer of Property Act, a general law, then it would be arbitrable. If it's governed by a special statute, then it is non-arbitrable. But if it is governed by Transfer of Property Act, it is arbitrable. So it is, so far as tenancy matters are concerned, the law now stands settled that tenancies, leases, licenses, anything to do with matters between landlords and tenants, between lessors and lessees, licensors and licensees, any matter relating to immovable property governed by the Transfer of Property Act would be non-arbitrable. Would be arbitrable. One can go to arbitration to have it resolved, While deciding this, several issues were also clarified, which fell for consideration in earlier judgments. One of Booz Allen was reiterated and was affirmed. So all the illustrations of Booz Allen, all these illustrations were affirmed by the large bench, saying that this is the correct law. Booz Allen itself, with regard to enforcement of mortgage, was also affirmed. So enforcement of mortgage is not arbitrable, was also affirmed. Next issues which arose for consideration was with regard to trusts. It was held that matters relating to trusts were not arbitrable, because matters relating to trusts are governed by the Indian Trusts Act, and there are special provisions with regard to matters relating to trusts. So any dispute amongst trustees in a trust is not arbitrable. Then was the issue of Consumer Protection Act. The Supreme Court said that the Consumer Protection Act is a special statute which has been laid down for the protection of the poor and the hapless who have small consumer disputes with regard to services and goods. Because of this special statute, we will not permit arbitration to interdict the process of giving relief to consumers through consumer forum and state consumer disputes tribunals. So consumer disputes issues were held can continue despite the existence of an arbitration clause. Then industrial disputes. Insofar as industrial disputes are concerned, there is the Industrial Disputes Act and several social welfare legislations. So industrial disputes were also held to be non-arbitrable, outside the purview of arbitration. Then was infringement of copyright. It was held that insofar as copyright is concerned, claim for copyright against a person is arbitrable. If somebody infringes a copyright, that can be resolved by arbitration if there is an agreement between the copyright holder and the violator. But if there is no agreement between the copyright holder and the world at large, then it is non-arbitrable. It laid down several tests in this judgment, and you will find the tests in this paragraph. This is paragraph 76, which I have set out in brief. These are the tests that the Supreme Court says that the judicial authority must look into when deciding whether a claim is arbitrable or not. One, when cause of action and subject matter when cause of action and subject matter of the disputes relates to actions in rem that do not pertain to subordinate rights in personam that arise from rights in rem. 2. When cause of action and subject matter of the dispute affects third party rights, have erga omnes effect. Erga omnes effect is a high sounding word, essentially means having third party rights. Requires centralized adjudication, and mutual adjudication would not be appropriate and enforceable. 3. When cause of action and subject matter of the disputes relates to inalienable sovereign and public interest functions of the state, and hence mutual adjudication would be unenforceable. Subject matter of writs under Article 226 essentially. 4thly, when the subject matter of dispute is expressly or by necessary implication non-arbitrable as per mandatory statutes. Just to give an example, the debts recovery, the Recovery of Debts Due to Banks and Financial Institutions Act, or the Surface Act, they have overriding effect. So disputes between the banks and financial institutions on the one hand and the debtor are non-arbitrable. That has been held by the Supreme Court because they relate to non-arbitrable as per mandatory statutes. While this was going on, another issue arose, which is the issue of fraud. Now, the original law as we understood it, the English law as derived by our courts, as followed by our courts, was that if an issue of fraud arises. Now, these tests are quite straightforward, and the illustrations are there in this judgment of the Supreme Court. So, the law insofar as this is concerned is well settled. What about the question of fraud? The English courts and our courts held that if an issue of fraud arises, somebody is alleging fraud against me, is raising aspersions with regard to my integrity, my character, my goodwill. The law was that in that case I must have a chance to vindicate my rights in open court. If somebody is casting aspersions on me, I must have my day in court. So the original view was that if there are assertions of fraud, the matter becomes non-arbitrable and must file a suit, have one's right vindicated in open court. But this gave rise to a lot of anomalies because fraud is something which just fell off our lips while drafting. And there will be allegations of fraud on anything and everything. So the Supreme Court distilled the law, and in this judgment itself, referring to earlier judgment, said that if fraud relates to that which goes to the root of the transaction itself and affects the making of the agreement itself, only then it is arbitrable. Otherwise, allegations of fraud, for example, that there is a fraud in accounting, or that the two parties acted in a fraudulent manner to carry out this sort of an act, under the statute or under the agreement, these are arbitrable. Anything that can be decided in a civil court can also be decided in arbitration. An action for specific performance of a contract can be decided in arbitration. In deciding an action for specific performance, more often than not, we are met with allegations of fraud, allegations of malpractices, allegations of accounting malpractices. To take everything out of the scope of arbitration would be actually a retrogative step. So the court said no, allegations of fraud are also arbitrable. So along with Booz-Allen's determination and the 6 examples given by it, in Vidya Trolia, the larger bench of the Supreme Court laid down a large number of illustrations as to when disputes are arbitrable and when disputes are non-arbitrable. One last issue that remained on this was with regard to accord and satisfaction. What happens if a party alleges accord and satisfaction? In other words, I make a claim against a party for 1 lakh. The other side says, no, I paid you 800. And it was agreed that this would be full and final settlement. Therefore, there is no dispute. There is a full and final settlement and there is a no due certificate. Then does the resultant cause of action, which has to diminish by the assertion of accord and satisfaction, by assertion of full and final settlement, by an assertion that there is a no due certificate, does that make it non-arbitrable? This question was also gone into by the Supreme Court in a judgment known as SBI General Insurance Company versus Krish Spinning. I don't think it's here. This is reported in 2024, SCC Online, SC 1754, a very recent judgment. This is also of a larger bench, with the then Honorable Chief Justice, Justice Chandrachud, delivering the main judgment. 3 judges bench, 2024, SCC Online, SC 1754. SCC Online, SC, in other words, 2024, SCC Online, Supreme Court 1754. I think this is part of the compilation of judgments that I have forwarded. Here the Supreme Court says that the assertion whether there is full and final settlement is itself arbitrable. The question whether there has been a full and final settlement, question whether a no due certificate which has been asserted by one party to exist, whether that is valid or that really whether the claim has to be discharged by that certificate is itself arbitrable. The Supreme Court noted that it is in the usual course one finds that in disputes between an employer and a contractor, when the employer is a huge monolith, for example the state or a public sector undertaking, contractors would not get payment unless they sign the no due certificate. If a contractor says, I will not sign the no due certificate, the contractor would not get paid at all, or its running account bills would be stopped, or its bank guarantees would be enforced and encashed. So there is what the Supreme Court says economic duress. Because of economic duress, contractors are more often than not compelled to sign documents by way of no due certificates. So in these cases, the circumstances under which the no due certificate was issued, whether it is valid within the meaning of the Contract Act, in other words, whether there is free consent of the parties in terms of the Contract Act, whether it is vitiated by undue influence, fraud, coercion, mistake, misrepresentation. These are all issues which are arbitrable. So merely by throwing a no due certificate in the face of the arbitrator or the arbitration court, it cannot be said that the dispute becomes non-arbitrable. It is arbitrable, and it is the arbitrator who will decide the validity of the claim. So this larger bench judgment of SBI versus Krish Spinning laid to rest the disputes which were there because there were conflicting views on this question of accord and satisfaction. As you know, a claim gets discharged in various ways. A claim gets discharged by performance and payment. A contract will be discharged by termination. A contract will be discharged even by accord and satisfaction. Now the validity of accord and satisfaction is itself an arbitrable dispute. So with this in mind, now a judicial officer before whom an action comes has all the armaments in his or her possession to decide whether to entertain an application. One last straw remains, that is, do I have territorial jurisdiction? Before we enter into section 9, 14, 34, etc., the last question is of territorial jurisdiction. In other words, whether this is the appropriate court of competent jurisdiction to entertain this action initiated by the parties before me. And this is sometimes a very fixed question because of the way in which the law has come about. The basic law is section 2(1)(EI). 2(1)(EI) with regard to domestic arbitrations. The last one should be small I, Roman 1. Essentially what it says is that in cases other than international commercial arbitration, it is the principal civil court of original jurisdiction in a district. You forget about the High Court having original jurisdiction because that is not applicable here. Having jurisdiction to decide the questions forming the subject matter of the arbitration if the same had been the subject matter of a suit. So the arbitration court will have to see that if a suit were to be filed before me, would I have jurisdiction? So if in a suit I would have jurisdiction, then in this arbitration action I would also have jurisdiction. How does one have jurisdiction in a suit? By following the principles of section 16 to 20 of the Civil Procedure Code. In other words, does defendant's place of residence, whether he works for gain, has its office, where does the cause of action arise? So if these four are satisfied, then the court is a court of competent jurisdiction. So far so good, no problems. Now there are two caveats to this. The first is the law as it stands. That first thing that one must see is, would I have jurisdiction to entertain this matter if instead of an arbitration action, this would have been a suit? In other words, if having jurisdiction to decide the questions forming the subject matter of the arbitration, if the same had been the subject matter of a suit. Straight, plain and simple. The second is, unlike in a suit where you have the suit being instituted with a plaint, and then all applications, all introductory applications, whether under Order 38, Order 39, Order 40, etc., are all filed in the suit. In an arbitration proceedings, there is no suit. There is no plaint being filed. So there is no parent court. Now, one party may file an application in one court, another party may go to another court and file an application. Say for example, two parties are residents of two different districts. The causes of action may have arisen in two different districts. So courts of appropriate pecuniary jurisdiction in two different districts or even two different states would have jurisdiction. A party is in Delhi, another party is Bombay. The defendant may have its office in Delhi, so Delhi would have jurisdiction. The cause of action may have arisen in Bombay, so Bombay would have jurisdiction. Cause of action may have happened in Calcutta, so Calcutta would also have jurisdiction in terms of section 16 to 20 of the Civil Procedure Code. This confusion is obviated because in a suit is filed in a particular parent court. So every application is filed there and there is no confusion. But in arbitration there is no parent court, no suit is filed. A party comes with an interlocutory application under section 9. Another party can go to another court. Then what happens? There is conflict of jurisdictions. There is one court being set up against another court. There is forum shopping. So to obviate that, this legislature had section 42. Section 42 is a provision under which this conflict is avoided. And section 42 says that if an action is filed in one particular court which has the proper jurisdiction, then all subsequent applications relating to the arbitration have to be filed there. There is no alternative. One cannot file an application in any other court. Whether before the arbitration, during the arbitration, or even after the arbitration. All applications have to be filed in that court and that court only. Please have a look at section 42. You will find that it starts with a non-obstante clause. Notwithstanding. So it doesn't matter what else is contained anywhere else. Notwithstanding anything contained elsewhere in this part or in any other law for the time being in force, where with respect to an arbitration agreement, any application under this part, means part 1, relating to domestic arbitration, has been made in a court, that court alone shall have jurisdiction over the arbitral proceedings, and all subsequent applications arising out of the agreement and the arbitral proceedings shall be made in that court and in no other court. So I have set out section 42 there. So this avoids conflict of jurisdictions, this avoids one court being set up against another court, and forum shopping is avoided. Whoever goes to the first court, and if that court is the court of competent jurisdiction in terms of section 21 EI, that is section 16 to 20 of the CPC is satisfied, then that court will be the only court which will have jurisdiction. Now you will find that this matter came up for consideration in this judgment of State of West Bengal versus Associated Contractors. This is also a judgment of 3 honorable judges of the Supreme Court. 2015, volume 1, SCC 32. Here what happened was that proceedings were instituted under section 9 for interim measures of protection by one of the parties. Yeah, in 5 minutes there. Proceedings were instituted under section 9 by one of the parties in the Calcutta High Court. That was during the pendency of the arbitration. Then an award was passed. Then the state of West Bengal, instead of going to the original court where the Section 9 proceedings had been filed, that is the High Court, they filed an application for setting aside the award in the Jalpaiguri District Court, saying that the Jalpaiguri District Court also has jurisdiction in terms of Section 21EI, because part of cause of action has arisen there. So the question went before the Supreme Court, can there be this sort of different courts assuming jurisdiction? And this, in this judgment, the Supreme Court decided once and for all that no, the first court which is invoked becomes the only court which will have jurisdiction. So this is so far as jurisdiction is concerned. We'll just stop for tea for a short while, but before that, may I just leave you with a teaser. All this that I've talked to you about with regard to jurisdiction, with regard to competence of a court in terms of Section 16 to 20 of the Civil Procedure Code, Section 42 of the Act, all becomes completely and absolutely useless and absolutely redundant the moment the parties designate a particular court to be a designated seat. Whatever we have learnt with regard to jurisdictions under the Civil Procedure Code, whatever we have grown up learning gives jurisdiction to courts, we have to unlearn the moment it comes to arbitration, when the parties agree that no, we will have X as a seat of arbitration. The basic law that we had learned as children growing up in the law was that the parties cannot by consent confer jurisdiction on a court which otherwise does not have jurisdiction. When there are several courts which have jurisdiction, the parties can choose one of the courts. We have forum selection clauses saying that courts at such and such alone will have jurisdiction. If that court otherwise would have jurisdiction, that is a perfectly valid clause and is not barred under Section 23 of the Contract Act. So parties can agree that courts at a particular place will have jurisdiction, so long as that court otherwise had jurisdiction. So between 10 courts or 5 courts which have jurisdiction, parties can choose one court. But now we are faced with a situation which we'll come to the moment we resume, is that, say, for example, there is a dispute between a party in Calcutta and a party in Gangtok. Dispute relates to a problem in Delhi. Parties can agree that the seat of arbitration will be in Goa. Then Gangtok, Calcutta, Delhi lose their competence and Goa becomes the court of competent jurisdiction. This is absolutely something which has come about new insofar as arbitration law is concerned, and something we have no concept about. We'll go into this aspect immediately after we resume. Now that way, in a break, am I going too fast, going too slow, is it alright? And the more important question, am I making the same question? The seat of arbitration was not there till the Supreme Court in 2012 in a matter relating to international commercial arbitration, not domestic arbitration, decided that there is a concept relating to seat. And in one particular paragraph of this judgment, it said this, and I just place this portion for your convenience. It says, this is the judgment of Balco versus Kaiser Aluminium. Balco versus Kaiser Aluminium, this is 2012, Volume 9, Supreme Court Cases 552. 2012, Volume 9, Supreme Court Cases 552. Balco versus Kaiser Aluminium Technical Services Incorporated. Supreme Court says this. This is what led to the spate of later judgments. Supreme Court says, in our view, the legislature has intentionally given jurisdiction to two courts. Why two courts? One is the 21EI court, which we have all seen a couple of minutes earlier. The other is a particular section that we have not seen yet, that is section 20. Please have a look at section 20 of the Arbitration and Conciliation Act. The heading is place of arbitration. One says the parties are free to agree on the place of arbitration. This is devoid of where the parties are, where the cause of action is, anything. Parties are free to agree on the place of arbitration. 2. Failing any agreement referred to in subsection 1, the place of arbitration shall be determined by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. And 3. Notwithstanding subsection 1 or subsection 2, the arbitral tribunal may, unless otherwise agreed by the parties, meet at any place it considers appropriate for consultation among its members, for hearing witnesses, experts, or the parties, or for inspection of documents, goods, or other property. So two places are considered in section 20, one which the parties may agree to be the place of arbitration. If the parties have not agreed, then the arbitral tribunal can fix the place of arbitration. The other place is where, notwithstanding whatever may be the place fixed by the parties, for convenience of witnesses, for convenience of the tribunal members to sit together, for inspection of documents, they may go to convenient places and have sittings. So this is a second provision in the statute which contemplates a particular place, the first being 21EI. So this is what is considered in this judgment of the Supreme Court. If I may place this once more. In our view, the legislature has intentionally given jurisdiction to two courts. That is, the court which would have jurisdiction where the cause of action is located, and the courts where the arbitration takes place. This was necessary as on many occasions the agreement may provide a seat of arbitration at a place which would be neutral to both the parties. Therefore, the courts where the arbitration takes place would be required to exercise supervisory control over the arbitral process. For example, if the arbitration is held in Delhi, where neither of the parties are from Delhi, Delhi having been chosen as a neutral place as between a party from Mumbai and the other from Kolkata, and the tribunal sitting in Delhi passes an interim order under section 17 of the Arbitration Act 1996, the appeal against such an interim order under section 37 must lie to the courts of Delhi, being the courts having supervisory jurisdiction over the arbitration proceedings and the tribunal. This would be irrespective of the fact that the obligations to be performed under the contract were to be performed either at Mumbai or at Kolkata, and only arbitration is to take place in Delhi. So this brought in a new line of thinking. Parties are at Kolkata and Delhi, cause of action has arisen either in Kolkata or in Delhi. But, Mumbai and Kolkata, parties are at Mumbai and Kolkata, causes of action in Mumbai and Kolkata, only arbitration sittings are held in Delhi. Parties agree that Delhi will be the place. The Supreme Court says courts at Delhi will assume jurisdiction. But this was in the context of an international commercial arbitration. But later judgments then decided to bring this and incorporate this concept into domestic arbitration also. And this happened primarily in the first judgment on the left hand side, Indus Mobiles Distribution Private Limited versus Data Mint Innovations Private Limited. 2017, Volume 7, Supreme Court Cases 678. Now in this judgment, which is now known as the Indus Mobiles judgment, the Supreme Court said that if the parties have designated a particular place as a seat of arbitration, the arbitration gets anchored to that seat. In other words, that place becomes the center of gravity insofar as the arbitration is concerned. and that is akin to an exclusive jurisdiction clause. In fact, these are the words that the Supreme Court said. In paragraph 19 of this judgment, 2017 7 SCC 678, a conspectus of all the aforesaid provisions show that the moment the seat is designated, it is akin to an exclusive jurisdiction clause. In paragraph 12 of this judgment, it quoted an earlier judgment which said, and I quote that portion, this is in paragraph 12 of Indus Mobiles, it is accepted by most of the experts in the law relating to international arbitrations that in almost all the national laws, arbitrations are anchored to the seat or the place or the situs of arbitration. Then it quoted an author, Redfern and Hunter, who concluded that the seat of arbitration is intended to be its center of gravity. This does not mean that all proceedings of the arbitration are to be held at the seat of arbitration. The arbitrators are at liberty to hold meetings at a place which is of convenience to all concerned. This may become necessary as arbitrators often come from different countries. Therefore, it may be convenient to hold all or some of the meetings of the arbitration at a location other than where the seat of arbitration is located. So this was a change in law and an absolute change in law. It changed anything and everything that we knew of how courts assume jurisdiction. So one throws into the river the situs of the respondent or the situs of the defendant, where defendant resides, works for gain, carries on business, where the causes of action are, merely because the parties have chosen a seat, which may have nothing at all to do with the subject matter. And that court now assumes jurisdiction over the arbitral proceedings, and that court becomes vested with power to exercise all powers under Part 1 of the Act, akin to an exclusive jurisdiction clause. That's what the Supreme Court says. So the law that stood in 2017 was that the moment the parties have designated a particular situs as a seat of arbitration, or if the parties do not designate, if the arbitral tribunal has designated a particular situs as a seat of arbitration, that is the end of the matter. Courts at that seat alone will have jurisdiction. So it now becomes important to see one more thing in the agreement between the parties when it comes by way of an action before a court. Did the parties designate a particular place as a seat? Because if the parties have so designated a place as a seat, then whatever may be the other aspects of the matter, including cause of action, situs of the parties, it becomes irrelevant, and the court does not have jurisdiction if the seat is designated as somewhere else. And this the parties can do at their whims and fancy. But if it is there, that's the end of the matter. Or the tribunal can also hold that we fix Delhi as a seat, although everything may have happened here. It happens quite often when we have arbitrators from Delhi or arbitrators from elsewhere, or the parties have, one of the parties is from elsewhere, and there is a contract which has clauses which are in the form of a standard form contract. Standard form contracts usually have such clauses. So this is another aspect to be noticed. Then there is a further addition to this law. Suppose the parties have not designated a place as a seat of arbitration. Suppose that the arbitrator has also not designated a particular place as a seat of arbitration, but the arbitration clause has a venue. All along we thought that the venue was irrelevant. The venue clause only related to the place where the arbitration sitting itself would take place physically. But now the Supreme Court in this later judgment says, even if the parties have not designated, the arbitrator has not designated a seat. If the parties have merely agreed to a venue in the agreement between the parties, the venue clause will operate as a seat. And if there is no other contrary indicia, the venue will be the seat. And that you will find in the judgment which I have noted on the right hand side there, which is BGS SGS Soma joint venture versus NHPC Limited. 2020 volume 4 Supreme Court cases 234. This is also a judgment of 3 honorable judges of the Supreme Court. And the relevant paragraph, if you see the text of the judgment of the report, it's at paragraph 82. I just place paragraph 82 for the convenience of all. On a conspectus of the aforesaid judgments, it may be concluded that whenever there is the designation of a place of arbitration in an arbitration clause as being the venue of the arbitration proceedings, the expression arbitration proceedings would make it clear that the venue is really the seat of the arbitral proceedings, as the aforesaid expression does not include just one or more individual or particular hearings, but the arbitration proceedings as a whole, including the making of an award at that place. This language has to be contrasted with language such as tribunals are to meet or have witnesses, experts or the parties, where only hearings are to take place in the venue, which may lead to the conclusion, other things being equal, that the venue stated is not the seat of arbitral proceedings, but only a convenient place of meeting. Further, the fact that the arbitral proceedings shall be held at a particular venue would also indicate that the parties intended to anchor arbitral proceedings to a particular place, signifying thereby that that place is the seat of the arbitral proceedings. This, coupled with there being no other significant contrary indicia that the stated venue is merely a venue and not the seat of the arbitral proceedings, would then conclusively show that such a clause designates a seat of the arbitral proceedings. So the law as it now stands is that when an application is filed on any of the provisions as I have enumerated there, before any of the courts which are principal civil courts of original jurisdiction in a district, before one actually goes into the merits, there are so many aspects to be considered. Is there an arbitration agreement which is valid under the law? Are the disputes arbitrable disputes? Whether this is the competent court, there are several issues to be considered. The parties may or may not raise the issues, but it becomes obligatory for the judicial authority to consider these aspects before going into the merits. Whether all the parties and all the causes of action are covered by the arbitration clause. So many aspects to be considered that we've been going through one after the other. Once all this is satisfied, then these are the provisions under which a court can intervene. And why are these the only provisions under which a court can intervene and no other provision? Does an arbitration court have the power, like in section 151 of the Civil Procedure Code, to do inherent justice? No. Because of the existence of a provision which is section 5. Section 5 is a special provision which limits the power of court to intervene only in respect of those matters which are contained in the Act and otherwise not. If you please have a look at section 5, the heading is Extent of Judicial Intervention. It again starts with the non-obstante clause. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. So if a litigant comes before a court and requests for reliefs which are not governed by these sections, and this is the compendium of all the provisions under which a court can intervene, then section 5 limits the court's power from giving any relief or entertaining this application. Because of section 5 and the way in which it is worded, starting with the non-obstante clause and ending where, except where so provided in this part. provided that courts can intervene only in these sections, otherwise not. Now, of these provisions, of course, section 11 we may disregard for the time being. That is the power of the High Court to appoint an arbitrator. Now we have section 9, 14, 27, 29A, 30A, 34, 36, 37 and 39. Of these, perhaps the most important are 9 and 34. What is 9? So far as 9 is concerned, really speaking, this is an amalgamation of Order 38, Order 39, Order 40. If you have a look at Order 38, Order 39 and Order 40 of the Civil Procedure Code, this is all contained here. With, again, the rider that there is an extra provision here which is not there in Order 38, Order 39 and Order 40. That is in 9, 1, IIE. It's like a residuary power. If you have a look at 9.1, which I will come to in a moment, gives the periods during which intervention may be granted, the periods during which the courts may give interim measures. Then I, Roman 1 and Roman 2 give the various provisions or the various issues in respect of which protection may be granted. E is something which is not contemplated under the Civil Procedure Code. Such other interim measure of protection as may appear to the court to be just and convenient. But the words just and convenient are something which is very common. If you have a look at Order 40 of the Civil Procedure Code, the Order 40 says the receiver will be appointed where it is just and convenient. But receiver is elsewhere contained here in ED. So just and convenient, if you see receiver is contained in D. D is interim injunction or appointment of a receiver. So just and convenient is not merely limited to receiver, to even other aspects not covered by A to D. So this is like a residuary power given to the courts to do wholesome justice. Two important aspects that I would like to mention here. In fact, I would like to mention three important aspects in respect of section 9. The first important aspect is the distinction between a civil court and an arbitration. In a civil court, whatever be the necessity, whatever may be the urgency, whatever may be the type of relief one wants under Order 39 with regard to injunctions, Order 38 with regard to attachment proceedings, with Order 40 receivers, whatever one wants, one has to file a suit. In that suit, we file interlocutory applications for interlocutory orders by way of applications for temporary injunction, receiver, attachment, etc. But you have to file a suit. There is no concept of filing this parent proceeding in arbitration. And it may take time for an arbitral tribunal to be constituted because it is a laborious proceeding under section 11. So if a party requires there's an imminent threat which requires immediate protection, where does the party go? That is why section 9 starts by saying, if you have a look at section 9, subsection 1, a party may before or during arbitral proceeding. So it contemplates a new situation, that there is no arbitral proceeding which has commenced, but something has happened which requires immediate protection. So even before the arbitral proceedings have commenced, an arbitral proceeding is said to commence by issuance of notice under section 21. A party requiring a dispute to be referred to arbitration is required to give a notice under section 21 of the Act. That is the date of commencement of arbitration. Then there is constitution of an arbitral tribunal. Before all that happens, also the court has power to give interim measures of protection. It says party may before or during arbitral proceedings or at any time after the making of the arbitral award. Please have a note of this. Arbitration has started, arbitration has concluded with an award, but the award is not immediately enforceable as a decree in terms of Order 21. Why? Because section 34 says that a party has 3 months and 30 days to make an application for setting aside of an award. Section 34 subsection 3, which we will come to, says a party has 3 months within which it has a statutory right to file an application for setting aside the award. It has a further 30 days during which time the court can condone delay. So 3 months and 30 days, which is equivalent to almost 4 months. So during that period, where will a party which has been successful in the arbitration proceedings go if there is an imminent threat of dispossession, of dissipation, of third party interest being created? So this is why this additional protection is given here. Before or during or at any time after the making of the arbitral award, but before it is enforced in accordance with section 36. So protection at 3 stages: before, during and after. This is a concept alien to civil procedure code. Before and after have remained as it is, but the protection given during the arbitral proceedings has now been watered down. Because when the arbitral proceeding has commenced, the arbitral tribunal or the arbitrator also has been given powers to give interim measures of protection. Similar to the powers that have been given in court under section 9. And that you will find in section 17 of the Act. If you have a look at section 17 of the Act, absolutely similar powers have been given to the arbitrator. 17 initially did not have such wide-ranging powers. Therefore, the legislature has brought about this amendment in 2019. And if you have a look at the subsections of section 17, you will find that they are exactly the same, word to word, ditto, the same as section 9. So the same powers are given to the arbitral tribunal to give interim measures of protection as are given to a court. Which is why the legislature has thought that when the arbitration starts, the arbitrator must have primacy to give interim protection and not the court. Which is why the section 9 has now been amended. And you will find that in subsection 3, the power of the court during arbitration has now been watered down. Let me place subsection 3. Once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that circumstances exist which may not render the remedy provided under section 17 efficacious. So the scope of section 9 now is before arbitration has commenced, full powers. After the award has been made and before it is executed, full powers. During arbitration proceedings, it has the power, but only if the remedy under section 17 is not efficacious. For example, if it requires the help of certain agencies to enforce its orders, maybe police directions are required, which cannot be efficaciously given by the arbitral tribunal, then the court retains its jurisdiction. The court has jurisdiction, but it must see whether the tribunal would not find it efficacious to give similar remedy. Then it will entertain. So the change in law is that before, during, after, during the arbitral proceedings, it's now watered down. The second aspect of the matter is, let us say we have a litigant who has filed an application under section 9 before the arbitration has started, got an interim measure of protection and now sits tight and does not start arbitration proceedings. It's possible. I've got my interim measure, I've got my injunction, I've got my receiver, and now I sit tight and don't start arbitration. The court found that this is something which is possible. After all, we are a nation of dishonest people. So it's possible that this may happen. So subsection 2 was brought in, that you have to initiate arbitration within 90 days. Please come to subsection 2, where before the commencement of the arbitral proceedings, a court passes an order of any interim measure of protection under subsection 1, the arbitral proceeding shall be commenced. It's mandatory. within a period of 90 days from the date of such order or within such further time as the court may determine. So one cannot get an order and then sit tight and do nothing. Once I've got an order, I have to start proceedings for appointment of an arbitrator by giving the notice under section 1, so the arbitral proceedings commence, so that the rights are ultimately adjudicated. In a civil suit, one files an application for interim injunction receiver in the suit itself by way of interlocutory applications. So suit continues. Here there is no suit. The court does not know whether at all this litigant will actually file an arbitration proceedings before the arbitrator. It gives an injunction or a receiver because of the imminent danger. So legislature steps in and says within 90 days you have to initiate, otherwise your order will go. So this is so far as section 9 is concerned. Now the question which came in, that all this is very well, but if you go through the Civil Procedure Code, Order 39, Order 38, Order 39, Order 40, there are various rigorous technicalities which have to be followed, particularly with regard to Order 38. And I may say so especially with regard to Order 38 Rule 5 with regard to attachment. If you have a look at Order 38 Rule 5 of the Civil Procedure Code, the tests are very stringent, because an order of attachment or an order requiring security to be furnished. This is not me. Where is this coming? Intervention of the court. Section 5 should apply. So rigors are there, particularly in proceedings with regard to attachment under Order 38 Rule 5, because it's a draconian power. One is really converting an unsecured creditor into a secured creditor by giving an attachment or a security. So you will find in the provisions of Order 38 several tests, and all the tests have to be satisfied before attachment or security can be given. Question arose is whether in section 9 these rigorous tests will apply or not. Initially the Supreme Court was of view that these tests would apply. But lately the Supreme Court, in a recent judgment of SR House Private Limited, this is ArcelorMittal, this is reported in 2022, Volume 20, Supreme Court Cases 178. Let me just check whether it's part of the, yeah. This is from ArcelorMittal, this is 2022, Volume 20, Supreme Court Cases, page 178. 2022, Volume 20, Supreme Court Cases, page 178. The Supreme Court in this judgment laid down that in deciding Section 9 applications, while basic principles of Civil Procedure Code cannot be ignored, the procedural rigidity of the Civil Procedure Code need not be adhered to. And the power of Section 9 is wide-ranging, and like in Order 38, we need to give actual instances of the party trying to escape beyond the jurisdiction of the court, or removing its properties beyond the jurisdiction of the court, or trying to dispose of its properties. Such rigorous tests are not required to be followed. On basic principles of that we have followed, like there being a prima facie case, the injury being irreparable, and balance of convenience being overwhelming in favor of one party, orders can be passed. And one needs to essentially see as to whether an impending arbitral award may be rendered a paper decree or not by the defaulting party. Rigorous tests prescribed in the Civil Procedure Code need not be followed in passing injunctions or receivers or attachment in proceedings under Section 9. So this is a very important judgment so far as proceedings under Section 9 is concerned. This so far as Section 9 is concerned, then we come to Section 14, which is termination of the mandate of an arbitrator. Now an arbitrator has been appointed. We are stuck with an arbitrator. Now one finds that the arbitrator may or may not be a suitable arbitrator. Is a party stuck with that arbitrator? The answer is yes, the party is stuck with the arbitrator unless the pigeonhole theory is satisfied. What is the pigeonhole theory? The statute has certain pigeonholes. If you can fit your case into those pigeonholes, then you can escape the arbitrator or otherwise not. And these pigeonholes are mentioned in section 14. What is the first pigeonhole? The first pigeonhole is that the arbitrator is de jure unable to perform his functions as arbitrator. That is, in law he is unable to perform his functions as arbitrator. What would be, by way of illustration, a de jure or in law inability to perform his functions? Earlier there was a lot of confusion and there are n number of examples that may come in, but a very easy, ready reckoner would be section 12 subsection 5. Section 12 subsection 5 says, and it has now brought in a schedule, which is the 7th schedule to the Act. If you have the Bare Act with you and you come to the 7th schedule, if you come to the 7th schedule, you will find that this schedule has been created in terms of section 12 subsection 5, and it gives several disabilities of an arbitrator which disqualify an arbitrator from acting as an arbitrator. And the illustrations are quite straightforward and they are appealing. It must be the case. For example, the arbitrator is an employee or a consultant or an advisor or has any past or present business relationship with a party, or the arbitrator currently represents or advises one of the parties or an affiliate of the parties. If you have a look at these, it is really something which would operate as prohibitions or disabilities from which there is no escape. So the 7th schedule has come in really as God sent to a large number of situations where one felt that this man cannot possibly be an arbitrator because of these disqualifications. But one was unable to actually frame them into statutory mandates. This has now come in as God sent, and this becomes one of the de jure disabilities under which his mandate would stand terminated by a court whenever any application is filed and a party says that this arbitrator suffers from these disqualifications. Now section 12 subsection 5 is the section under which this schedule has been framed. Section 12 subsection 5 essentially says that these are disabilities which prohibit a person from being appointed as arbitrator. However, post-appointment, the parties can enter into an express agreement under which they can allow that party to continue to be an arbitrator. There is a protection given in section 12 subsection 5. It says, notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or council or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator, provided that parties may, subsequent to disputes having arisen between them, waive the applicability of this subsection. So post disputes, parties can waive the applicability and say we have no problem with this person being an arbitrator. But otherwise, these are statutory prohibitions. So a person is de jure in law unable to perform his functions as an arbitrator. The next pigeonhole is de facto disability. So a person is so unwell that he cannot perform his functions as an arbitrator. Or a person in a matter which requires urgent conclusion, he has to give an undertaking that there is nothing which prevents me from completing the proceedings within the time prescribed, but he is not available at all. So these are factual disabilities. So de facto unable to perform his functions. So this is in section 14A, 14(1)A, says the mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator if 1. He becomes de jure, or B. de facto unable to perform his functions, and C is or for other reason fails to act without undue delay. He keeps the matter pending. He's a very busy lawyer or a very busy retired judge having n number of arbitrations. he is unable to give time. Then in subsection B is if he withdraws from his office. The arbitrator himself decides that I cannot continue. He withdraws from his office. Or the parties agree to the termination of his mandate. Then what happens is that his mandate terminates and a new arbitrator can be appointed. But if despite the existence of these contingencies or these circumstances, he does not terminate his mandate, then one or more of the parties can approach the court under section 14. And that power is in section 14 subsection 2. Again, this court will be the same court as we've discussed earlier. 21EI read with section 42 read with seat. So under section 14, parties can approach the court that you terminate the mandate of this man. That's 14. Then we come to 27. In 27 is really equivalent to the power in the civil procedure code under which the court has power to summon witnesses or summon evidence. So here what happens in section 27 is that the tribunal by itself does not have the power to summon a witness or summon a third party as a witness or call for production of documents or issue subpoenas. So the tribunal gives an order that this is a matter which requires production, and the tribunal or a party with the approval of the tribunal can approach the court. What usually happens is the party who requires the evidence or a special person to come as witness, a third party evidence or subpoena for production of documents, with the approval of the arbitral tribunal would approach the court. And the court would render the same assistance as the civil court would do with regard to production of witnesses or production of documents. And that is section 27. So this is a third sort of power of a court which is exercising jurisdiction under the Arbitration Act. This is 27 subsection 1. Subsection 2 really gives the procedural power, what is to be contained in the application. And please come to 3. The court may, within its competence and according to its rules on taking evidence, execute the request by ordering that the evidence be provided directly to the arbitral tribunal. So one applies before the court, saying that this is a relevant witness who needs to be produced, or a subpoena needs to be issued for production of these third parties, for production of documents, and the court would issue the process and direct the same be produced directly before the tribunal. So that's 27. Then we come to 29A. 29A is a power which is increasingly being used because of the inability or the impossibility of tribunals to finish the proceedings within the prescribed time. The power to extend time is with the court. Again the same code, 21E, 42, seat, that code. Now what is the prescribed time? Prescribed time is a little vague because the point of commencement of arbitration is known. Moment section 21 notice is issued by a party requesting the disputes to be referred to arbitration, arbitration is deemed to have commenced. But the time cannot start then itself because that's only a notice being issued. Then if the parties agree to an arbitrator, then the tribunal is constituted. If the parties don't agree, then the parties have to approach the High Court under section 11 for constitution of a tribunal. Then the tribunal is constituted. Maybe it may take a few months to a year. It may take even longer, depending upon the business of the court. Then the tribunal gives directions of filing of pleadings. This is where the confusion and the controversy starts. The statute says that the pleadings, the statement of claim and the statement of defense must be filed within a period of 6 months. The intention was that it should be time-bound arbitration. Now let us say the statement of claim and the counter statement, total period is given 6 months. Section 23 subsection 4. I should take that immediately with you. But say the claimant himself takes 5 months, or 5 months and 29 days. The other party does not have any opportunity to file its counter statement or its statement of defense within the 6 months. So it's an impossibility. With the 6 months, major period may be taken by one party. Or let us take an example where a party files a statement of claim within 4 months, statement of defense is filed after 2 months, 6 months, then this claimant wants to amend its statement of claim. And amended statement of claim on issues which are found to be relevant and necessary for amendment. Maybe subsequent developments have taken place. Subsequent causes of action need to be incorporated. So the amendment also changes the entire timelines. So this starting point of completion of pleadings has been held by the courts to be directory and not mandatory. And the timeline for the completion of the reference starts, or day 0 starts from the date of completion of pleadings. Section 29 capital A states that the entire arbitral proceeding must be completed within 1 year. 1 year from when? From the start point cannot be fixed with definitiveness because of all these issues that I mentioned, but from the date of completion of pleadings, and then 1 year. After 1 year, what happens? After 1 year, the mandate of the arbitrator would stand terminated unless the parties, by consent, agree to extend the time. So after 1 year has expired, the parties don't need to go to court. By consent, they can agree that we shall extend the mandate of the tribunal. For how long? A maximum period of 6 months. If the parties cannot agree because by that time one of the parties knows that it will lose, or it does not want to have the arbitrator, or for any other reason does not want to give consent, then itself the party would have to approach court. But otherwise, if there is consent, the 6-month extension can be without approaching court or seeking court's intervention. But after this 1 year, that is completion of pleadings, 1 year, then 6 months. So 1.5 years have expired, arbitration award is not yet ready, the parties need further extension, then the parties can give no consent any longer. Then they have to approach the court. And then it's the court's jurisdiction to extend, and sometimes if the court finds that the arbitrator has been defaulting in completing, the court can even penalize the arbitrator by reducing his fees up to an extent of 5%. And the arbitrator can also, and the court can also at the time of extending the time, say, I find that the arbitrator is a person who has not been dealing with the arbitration properly, so I'm removing the arbitrator and appointing a new arbitrator. So here, substantive rights have been given under section 29A to consider the conduct of the arbitrator and the conduct of the parties in the arbitral proceedings while extending time. Let's quickly take a review of these provisions that I was mentioning. First, we come to section 23, subsection 4. If you have a look at section 23, subsection 4, the heading of the section is Statement of Claim and Defense. 23 subsection 4 says Statement of Claim and Defense under this section shall be completed within a period of 6 months from the date the arbitrator or all the arbitrators, as the case may be, receive notice in writing of their appointment. Why all the arbitrators? There may be a panel of 3 arbitrators, so when the last arbitrator received notice from that day onwards. So 6 months. And then we come to 29 capital A. 29 capital A, 1 says the award in matters other than international commercial arbitration shall be made by the arbitral tribunal within a period of 12 months from the date of completion of proceedings under section 23(4). So, commencement of arbitration, appointment of arbitrators, direction given for pleadings, completion of pleadings, which is ordinarily 6 months. In any case, completion of pleadings, 1 year, mandate stands terminated unless the parties have agreed to extend the mandate by 6 months. Where do I get the 6 months? Subsection 3. Parties may by consent extend the period specified in subsection 1 for making award for a further period not exceeding 6 months. So by consent, further 6 months. After 6 months, what happens is subsection 4. If the award is not made within the period specified in subsection 1 or the extended period specified under subsection 3, the mandate of the arbitrator shall terminate unless the court has, either prior to or after the expiry of the period so specified, extended the period.
Sir, I have one question.
Yes, please.
Between 2016 and 2019, 29A required that the mandate of the arbitrator would start from the date of reference. From the date of reference, which I think 2019 amendment again brought it back.
223(4).
Yes, yes, sir. So between 2016 to 2019, those arbitration proceedings which did not conclude within 12 months, apart from the period which the parties had and the court had the power, from the date of reference, so should that be considered as non-est, that determine the arbitrator's power?
See, I follow your question. It's a very interesting question. The courts have gone into this question and have gone into question with whether by conduct the parties have extended the time. And in the particular case that I immediately recollect, the courts held that since both parties participated in the reference, even after completion of the period from the date of reference till 1 year, without express consent, by conduct they've extended the time.
By conduct, sir?
By conduct. Because one may, usually what happens is extension is recorded in the minutes of the arbitrator's proceedings or by letters. But if the participation in the reference itself by conduct extends the time.
But if the Act requires that it has to be in writing, sir, will the conduct come into?
No, the Act does not require in writing.
I think the Act says that if the parties agree,
yes,
in writing, 29A.
Please have a look at subsection 3.
By consent.
Yes.
So if they participate, that is...
That is extension by conduct.
Otherwise, between 2016 to 2019...
Yes, this anomaly was done away with by this amendment which said no from the date of completion of pleadings.
So what was the reason of this particular amendment between 2016 to 19 only, and again coming back from the date of completion of the pleadings?
Because there were so many anomalies in that provision, because one never knew as to how the arbitration would come to an end. Because one does not have a fixed timeline from when it starts. Because you see, under the 1940 Act, there was a provision of the arbitrator entering upon reference. And the pre-amendment portion that you're referring to said from the date when the arbitrator enters upon reference. And entering upon reference is a concept alien to the 1996 Act. You will not find this entering upon reference phrase anywhere in the statute, except in this provision for extension.
There was an explanation for that.
Yes, so they had to add in an explanation. But they found that this is creating a whole lot of confusion. This 1940 concept being incorporated into the 1996 Act of arbitrator entering upon the reference was an alien concept, because we have here the concept of commencement of arbitration. Irrespective of when the arbiters actually start arbitration, arbitration has already commenced. If you remember, under the 1940 Act, till the arbiters wrote, "We hereby enter upon reference," arbitration was not deemed to have commenced. Here the mere notice by a party saying that we intend the adjudication of disputes by arbitration commences the reference. This became very necessary, this notice, because one never knew as to what would be limitation. In a suit, the filing of the plaint stops the clock of limitation. In arbitration, there is no plaint. So when does the clock of limitation stop? Which is why it was mandatory for the legislator to think of a way in which the clock of limitation could be stopped. Limitation starts from the date of accrual of cause of action, but it must have an end point. So that became very confusing. So this concept of section 21 came in, that the issuance of notice under section 21 and receipt of that by the other party commences. So entering upon reference became redundant, which is why the entry upon reference had to be done away with by the amendment, because it was a concept which was no longer required. It was really otious and infructuous. But you're absolutely right that during this interim period there was this confusion. But now also there is a confusion because, in fact, a confusion created by the Calcutta High Court, which has now been resolved. Suppose we know when the pleadings have been filed, period of 1 year. Now, parties give their consent for 6 months. 6 months expires. If a party files an application after expiry of 6 months, courts would hold that this application for extension is not valid. You have to apply for extension before expiry of the time. Because the moment time expires, arbitrator's mandate has to terminate it. And the arbitral proceedings has to terminate it. If arbitral proceedings has to terminate it by expiry of the mandate, how can we ex post facto retrospectively extend the time? So that has now been clarified by saying no, this would make it unwieldy. Because what essentially would happen is that if the mandate is not extended, the litigants cannot be left at sea. The disputes have not been resolved. Claims have not been adjudicated. So what the party would have to do is perforce commence an arbitration all over again. This would be anathema to the concept of arbitration. So the Supreme Court has now said no, the application for extension of time can be made either before or even after. But the moment an application is made, the mandate automatically starts to run. And one does not wait for the court's order that the mandate has been extended.
Because this becomes one of the ground for challenge.
In 34. When a party has no other ground for challenge, this is the first challenge that puts up. The extension was when the mandate was not there because there were proceedings are null and void.
Yes. And that
it's a nullity.
We did not consent at all. And that the proceedings went on, we did not have any choice but to participate.
No, they had a choice to participate.
No, that is what...
They
yes.
contained.
And in some of the matters, there is also an application mentioning that we protest or we don't consent. But, like you said, by conduct, they participate and they go on. It's these kinds of matters.
People keep on participating, putting in a letter saying that we are participating under protest. Now, so far as this is concerned, moment an application is filed, one need not wait for the court's order. Extension is deemed to have happened. That is in the section itself.
Correct. Thank you.
If you come to the second proviso under subsection 4, provided further that where an application under subsection 5 is pending, the mandate of the arbitrator shall continue till the disposal of the said application. So mere filing of the application by a party is sufficient for the mandate to continue. And now with the Supreme Court having said that even post-expiry application can be made, whatever may have been the frailty or the issue of the validity of the proceedings, that is done away with because even post-facto application is good enough to revive everything. So this issue really has got sorted out. The confusion between entering upon reference and time starting from there and completion of proceedings and time starts there. It has worked itself out. And so far as the extension of the mandate is concerned, now extension of mandate is again linked to section 32. If you have a look at termination of proceedings under section 32, this is the ground which is really canvassed. The arbitral tribunal, the arbitral proceeding shall be terminated by the final arbitral award, which is obvious, or by an order of the arbitral tribunal under subsection 2. Arbitral tribunal shall issue an order for the termination of the arbitral proceedings where A, the claimant withdraws his claim. Unless the respondent objects to the order and the arbitral tribunal recognizes a legitimate interest on his part in obtaining a final settlement of the dispute, or B, the parties agree on the termination of the mandate, or C, the arbitral tribunal finds the continuation of the proceedings has for any other reason become unnecessary or impossible. So the moment the period is over, parties have not extended, nobody has applied to court for extension, it is incumbent upon the non-defaulting party or the other party to apply to the arbitrator and under section 14 and say that it is now impossible for you to continue, and you pass an order for termination of the proceedings because it is no longer, it is now unnecessary or impossible for you to continue. That not having been done and that party continuing with the proceeding without filing an application under section 14 in the court saying that arbitral proceedings cannot continue because he is now de jure and de facto unable to perform his functions because his mandate is over. That party is deemed to have given by conduct his consent or acquiescence in the continuation of the proceedings. So you have to link this 29A with 14 and 32. Now this is so far as 14 is concerned. Then 29A is concerned, and 29A, as I said, the court can look into the conduct of the arbitrator and reduce his fees. That you will find in the first provider of subsection 4. By as much as 5% his fees can be reduced. And then not only there is a provision of giving a penalty, but there is also provision for giving him a commission. These concepts are completely non-judicious. The court saying that I am penalizing or that I am going to give a benefit to an arbitrator is something which is not something which is contemplated. But you will find that this provision for giving additional remuneration you will find in subsection 2. If the award is made within a period of 6 months from the date of the arbitral tribunal entering into reference, the arbitral tribunal shall be entitled to receive such additional amount of fees as the parties may agree. So parties may give him a bakshish. Or if he does not finish within 1.5 years, court may penalize him. Poor fellow. Then there is a provision for removal. Please see subsection 6. The court can even remove him. While extending the period referred to in subsection 4, it shall be open to the court to substitute one or all the arbitrators. So there is a provision for removing him also. And then costs can be imposed upon the parties. If the parties have been ensuring that the proceedings have been continued, that is subsection 8. So costs can be imposed including exemplary costs. So that is 29A. Then we come to this humongous provision which is section 34. Nobody knows what is the law here. Nobody knows. And every time we think that we know the law is changed. The law has been constantly evolving so far as section 34 is concerned. Section 34 is something I think is daily bread and butter for all of you. Not for me, so I am learning every day. It really has 3 parts, or so I believe. The first part is 34(2)A. The second part is 34(2)B. And the third part is 34(2)A. I am taking the law as it stands today. Now you will find that there is a subtle difference between 34(2)A and 34(2)B in the way it is worded. I think this is a little lost sometimes. 34(2)A relates to all those issues which are apparent on the face of it, which relate to statutory violations of the arbitration law. 34(2)B is something which is not relatable to exactly violations of the arbitration law, but other grounds. But if you look at the way in which 34.2a commences and 34.2b commences, you will find a sea of difference. Let me just elucidate on this point a little bit in details. Let's have a look at 34.2a and the grounds first. Let's look at Roman 1 to Romans 5. One is party was under some incapacity. That means maybe lack of free consent under the Contract Act, Section 10, etc. Arbitration agreement is not valid under the law to which the parties are subjected it, or failing any indication thereon under the law for the time in force. So the arbitration agreement is not valid. An arbitration agreement is valid under the law which is applicable insofar as contracts are concerned. Then party was not given proper notice of the appointment or of the arbitral proceedings, or was unable to present his case. So this is natural justice. Then 4. Our arbitral award deals with a dispute not contemplated by or not falling within the terms of submission to arbitration. In other words, the arbitral award relates to matters beyond the scope of the arbitration, or beyond the bounds within which the arbitrator was to confine his jurisdiction. And 5th is the composition of the arbitral tribunal, not in accordance with the agreement between the parties. Apparently seems to be pretty straightforward and not much dispute with regard to assessment whether these grounds exist or not. And there's not much controversy. If it exists, one can make out on the face of the pleadings and the award itself. But please see how this section starts. I am not on 1 to 5 because all of you are more aware than me of quickly assessing whether these grounds exist. But please see how the section starts. It says, the party making the application establishes on the basis of the record of the arbitral tribunal that. So here the onus is on the parties which is making the application to establish on the basis of the records of the arbitral tribunal. So the applicant before you must in its application expressly aver these grounds. Must say that the award is initiated because of the existence of these grounds and prove it from the basis of the records. So the onus is on the party to make an application making out these grounds. Now please see how the next portion starts. Why did the legislature make the difference between A and B? In B you will find it does not say that the party making the application establishes. It says the court finds that. So the onus here is shifted from the applicant to the court. What are the grounds? Not capable of settlement by arbitration, and B, conflict with the public policy of India. The Supreme Court says that if the challenge to the award is limited to B, that it is in conflict with the public policy of India, or it is not capable of settlement by arbitration in law in India. Say for example, a dispute under the Foreign Exchange Maintenance Act, or a dispute with regard to matrimonial disputes, or a mortgage dispute, the ones we have discussed. Then it is within B, not within A. Then the onus is on the court. So we find more often than not, one of the grounds taken by the respondent, the award holder, is that seeing the application, this ground is not taken. In the section 34 application, the petitioner or the applicant has not made out this ground. That is relevant and material if it falls within 2A, but not relevant if it falls within 2B. Because in 2B it is a court's duty to ascertain whether public policy has been violated or not, whether it is an arbitrable dispute or not. The whole body of cases on this which says that this subtle difference exists. And one need not make out this case in the application, and it is sufficient if the court finds. So one can argue out this in court without having to actually make out these averments or these grounds in the application. Then 2A is separate altogether. Now 2A is when, if you find here, it is patent illegality appearing on the face of the award. So we find in 2A grounds which are relatable to issues which are straight and plain on the face of it. There is really no difference. 2B, The first ground is again not much in dispute, it's whether the dispute is arbitrable. The second one is public policy. So we need to go into a little bit of depth as to what is public policy. And the next ground, 2 capital A, is whether it is patent illegality or not. Now, insofar as the explanations are concerned, the explanations are very important. The explanations to 2B are very important. The explanations are relatable to public policy and explains what is public policy. For the avoidance of any doubt, it is clarified that an award is in conflict with the public policy of India only if. So this is an exhaustive provision. This is not inclusive. 1. The making of the award was induced or affected by fraud or corruption or was in violation of Section 75 or Section 81. We may ignore Section 75 and 81 for the time being because they are sections relatable to conciliation. In Section 81 is the provision relating to confidentiality, and Section 81 is a provision relating to admissibility of documents placed before the conciliator. Now, if there is an arbitral award despite failure of conciliation, then 75 and 81 come in, otherwise not. So, award was the making of the award was induced or affected by fraud or corruption. Please note that it is not the transaction which was induced or affected by fraud or corruption. It is not the act of the parties while the transaction was unfolding where the fraud or corruption came in, but the making of the award. The making of the award is pointing the needle of suspicion at the arbitrator. Because who is in charge of making of the award? It is the arbitrator. So here the direct allegation is that the arbitrator in making the award was actuated by fraud or corruption. The second aspect is if it is in contravention with the fundamental policy of Indian law. And third is if it is in conflict with the most basic notions of morality or justice. Now let's go back a little. Initially we did not have this explanation, and you will find from the Bare Act, the explanation came about only in 2015. Now prior to the amendment, you will find the amendment was here. It may be at the bottom of the page as a footnote. You will find that the second part was not there. In the explanation, Roman 2 and Roman 3 were not there. Only Roman 1 was there. So these are later additions. Now the pre-amendment 34 subsection 2B was only if the making of the award was induced or affected by fraud or corruption or 75 or 81. So here public policy was limited to making of the award being induced or affected by fraud or corruption. There was this judgment of the Supreme Court, an old judgment of the Supreme Court in a matter called Renusagar Power Company Limited versus General Electric Company Limited. This judgment is of 1994. In 1994, the Supreme Court laid down certain tests to explain what is public policy. And these tests are threefold tests. So in Renusagar, the Supreme Court said that the test to determine what is public policy is if it is in accordance with fundamental policy of Indian law, if it is in accordance with the interest of India, and thirdly, if it is in accordance with justice or morality. So this is what was there as public policy. Fundamental policy of Indian law, interest of India, justice or morality. Which so far as fundamental policy of Indian law, the Supreme Court gave an example in that case itself. For example, in violation of the foreign exchange laws with regard to Foreign Exchange Maintenance Act. That is in violation of the fundamental policy of Indian law. So that would be opposed to public policy. Then we came in 2003, there was this judgment called ONGC versus SAW Pipes. In ONGC versus SAW pipes, which is really not material now, but it is to be remembered that apart from these three concepts of public policy, which were enunciated in Renu Sagar, three means fundamental policy of Indian law, interest of India, and justice or morality, they added a fourth ground. The fourth ground being patent illegality. Supreme Court in ONGC versus SAW pipes added this fourth ground called patent illegality. After SAW pipes came about this amendment. So what the amendment really did was that from the judicial concept of what is public policy, the concept of patent illegality was taken out and was brought in by way of statutory amendment in 2 capital A. So 2 capital A essentially is a result of judgment law now given legislative recognition. Patent illegality was recognized for the first time in ONGC versus SAW pipes in 2003. This is 2003-5 SCC page 705. Patent illegality was recognized as an independent ground in section 34(2) capital A. If I may read 34(2)(a), an arbitral award arising out of arbitrations other than international commercial arbitration may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. So now what happens is, we are left with fundamental policy of Indian law in the explanation. Of course, fraud and corruption remain with the arbitrator's fraud or corruption, but we are left with fundamental policy of Indian law and we are left with patent illegality. So we really have to understand, if I may put it this way, what is the present law in relation to what is fundamental policy of Indian law and what is patent illegality. The rest of the cobwebs can be really brushed aside. What is fundamental policy of Indian law has been defined, and what is patent illegality has also been defined in 2 basic judgments. And I believe that these 2 basic judgments really take into account the entire law as existing today. One of the judgments is Associated Builders, which is 2015. I have given these 2 judgments in the note. 2015, volume 3 SCC 49. It's at the bottom, but it's been interrupted right now, how to take it up. The important judgments. The 2 judgments are Associated Builders versus Delhi Development Authority, which is reported in 2015, volume 3 SCC 49. And the second one is SsangYong. SsangYong is SsangYong Engineering and Construction Company Limited versus NHAI, which is 2019, volume 15 SCC 131. What we'll do is, because SsangYong is a later judgment, what we'll do is see what SsangYong says, because SsangYong says this is fundamental policy of Indian law. Fundamental policy of Indian law is as defined in paras such and such and such and such of associated. So we'll know exactly what that is. And so far as patent illegality is concerned, SsangYong says it is as mentioned in paras such and such of associated. So it's very easy to connect the dots. So let's come to what is fundamental policy of Indian law. Fundamental policy of Indian law is explained in paragraph 34 of SsangYong. This is one paragraph which says what is fundamental policy of Indian law. I just place this one sentence or 2 sentences of SsangYong, this 2019 judgment. What it says is, what is clear therefore is that the expression public policy of India, whether contained in section 34 or in section 48, would now mean the fundamental policy of Indian law as explained in paragraphs 18 and 27 of Associate Builders. That is, the fundamental policy of Indian law would be relegated to Renu Sagar understanding of this expression. So SsangYong in paragraph 34 says, you want to know what is fundamental policy of Indian law? Look at Associate Builders and see paragraphs 18 and 27 of Associate Builders. And go back to Renu Sagar. whatever is explained as Renu Sagar is fundamental policy of Indian law. So we need to only look at two paragraphs of associate builders to understand this concept of fundamental policy of Indian law, paragraphs 18 and 27. What is paragraph 18 of associate builders? That's the 2015 judgment. In paragraph 18, Renu Sagar has been dealt with. It explains what is Renu Sagar, and it gives, apart from explaining whatever I have explained about Renu Sagar, gives two illustrations. It says that a statute enacted for national economic interest to ensure the nation does not lose foreign exchange, which is the Foreign Exchange Regulation Act. If you defy that, that is opposed to fundamental policy of Indian law. And secondly, it says disregarding orders passed by superior courts in India would be a contravention for fundamental policy of Indian law. So A, you cannot do acts which are opposed to the national economic interest and statutes which relate to national economic interest. And secondly, you cannot disregard orders of superior courts. I mean the arbitrator, in passing the word, cannot disregard orders of superior courts. Any of these two would be opposed to fundamental policy of Indian law. This is paragraph 18. Paragraph 27 essentially again summarizes that in 4-5 lines. I'll just place this. It says, it has already been seen from Renu Sagar's judgment that violation of the Foreign Exchange Act and disregarding orders of superior courts in India would be regarded as being contrary to fundamental policy of Indian law. To this, it could be added that the binding effect of judgment of a superior court being disregarded would equally be violative of the fundamental policy of Indian law. So fundamental policy of Indian law is now 3 grounds. One is disregarding statutes which relate to the economic interest of the country. 2, disregarding orders of superior courts. 3, disregarding binding effect of judgments of superior courts. So this is essentially fundamental concept of fundamental policy of Indian law, disregarding the entire judicial plethora of judgments and whatever comes with it. This is essentially, if I say so, distilled 3 points of fundamental policy of Indian law. Then is what is the concept of patent illegality appearing on the face of the record. This is the only concept which remains. Again, patent illegality has been explained in Sanyong 2019. And in patent illegality, it says in paragraph 38 and paragraph 40, these 2 paragraphs of Sanyong are important, and we may ignore the rest of it. In paragraph 38, what it says is, paragraph 38 of Sanyong, it is also made clear that reappreciation of evidence, which is what an appellate court is permitted to do, cannot be permitted under the ground of patent illegality appearing on the face of the award. So, under the guise of patent illegality, one cannot reappraise evidence. One cannot probe into the mental process of the arbitrator and assume jurisdiction over sifting through the evidence all over again. Because the arbitrator is the master of the quality and quantity of evidence. That is one aspect. The second aspect is contained in paragraph 41 of Sanyong. What it says is, what is important to note is that a decision which is perverse, as understood in paragraphs 31 and 32 of Associate Builders, while no longer being a ground for challenge under public policy of India, would certainly amount to patent illegality appearing on the face of the award. So again, we have to look into these 2 paragraphs only of Associate Builders, paragraphs 31 and 32. So law really becomes clear and succinct once we get rid of the irrelevant paragraphs and come to the root of it. Patent illegality, 1, you cannot reappraise evidence, and secondly, have a look at what paragraphs 31 and 32 of Associate Builders say. And what do paragraphs 31 and 32 of associate builders say? Paragraph 31 gives the tests. I just place it for your convenience. The third juristic principle, this is paragraph 31 of associated. The third juristic principle is that a decision which is perverse or so irrational that no reasonable person would have arrived at the same is important and requires some degree of explanation. It is settled law that where, 1, a finding is based on no evidence, or 2, an arbitral tribunal takes into account something irrelevant to the decision which it arrives at, and 3, ignores vital evidence in arriving at its decision, such decision would necessarily be perverse. So the long and short of it is, we have to see whether the finding of the tribunal is based on no evidence at all, or the tribunal has taken into account irrelevant considerations, or 3, it has ignored vital evidence. If either of these 3 appear, it is perverse. If it is perverse, it is a blatant illegality. Straightforward arithmetical equation. And we cut out the rest of the wharf and the shaft. It's like mathematical precision. Fundamental policy of Indian law also. A, is a statute which relates to economic issues. B, ignoring judgments of superior courts. 3, ignoring binding effects of matters of superior courts in the matter in which is being dealt with. Patent illegality. A, no reappreciation of evidence. B, finding based on no evidence. C, taking into account irrelevant material. And 4thly, ignoring vital evidence. That's it. One additional aspect is with regard to construction of the contract. Insofar as construction of the contract is concerned, here there is one paragraph of Sangyon which is relevant, that is paragraph 40. And the rest of the hundreds of pages, I think, in my very humble submission, can be ignored. Paragraph 40 of Sangyon says, again it refers to two, 3 paragraphs of associated. Sangyon is really like a ready reckoner. Paragraph 40 says the change made in section 28(3) of the Amendment Act really follows what is stated in paragraphs 42.3 to 45 in associate builders. Namely, that the construction of the terms of a contract is primarily for an arbitrator to decide. Unless the arbitrator construes the contract in a manner that no fair-minded or reasonable person would. In short, that the arbitrator's view is not even a possible view to take. This is summarizing 42.3 to 45. So what is it? The construction of the terms of a contract is primarily for an arbitrator to decide. Unless the arbitrator construes the contract in a manner that no fair-minded or reasonable person would. In short, arbitrator's view is not even a possible view to take. The question is it possible? Is it plausible? It may be plausible, but it is not possible at all. If it is either of the two, it's good enough. Court will not intervene. That is paragraphs 42.3 to 45. So one just needs to have a look at paragraph 40 of Sangyon, which relates to 42.3 to 45 of associated. And this is exactly what associated says in paragraph 42.3. It says that last contravention must be understood with a caveat. An arbitral tribunal must decide in accordance with the terms of the contract. But if an arbitrator construes a term of the contract in a reasonable manner, it will not mean that the award can be set aside on this ground. Construction of the terms of a contract is primarily for an arbitrator to decide, unless the arbitrator construes the contract in such a way that it could be said to be something that no fair-minded or reasonable person would do. Then it gives examples in paragraph 43 to McDermott and paragraph 44 to MSK projects and paragraph 45 to Rashtriya Ishpat. And it concludes by saying, and if I may quote this, because this actually gives the crux, this is, I'm quoting from 42.3 to 45 of associated. The umpire has considered the fact situation and placed the contract on the clauses of the agreement which according to him was the correct one. One may at the highest say that one would have preferred another construction of clause 17.3, but that cannot make the award in any way perverse, nor can one substitute one's own view in such a situation in place of the one taken by the umpire, which would amount to sitting an appeal. The court, while considering challenge to an arbitral award, does not sit in appeal over the findings of the decisions of the arbitrator, which is what the High Court has practically done in this case. The umpire is legitimately entitled to take the view which he holds to be the correct one, after considering the material before him and after interpreting the provisions of the agreement. If he does so, the decision of the umpire has to be accepted as final and binding. So, cutting through all these chaff, this is the way that I read section 34. And if we read it in this fashion and we follow the mathematics, then I don't think one can go wrong. Now, these two judgments, along with what I felt is the way to look at section 34, has been considered and approved by a recent 3 judges bench of the Supreme Court in Delhi Metro Rail Corporation Limited. This is Delhi Airport Metro Express Private Limited. This is 2024. I've also given this judgment in that compilation which I've sent. 2024, volume 6, SCC 357. This is 2024, volume 6, Supreme Court cases 357. In my very respectful view, this recent judgment of the Supreme Court says exactly the way I tried to place it before this audience. In fact, in this Delhi Metro Railway Corporation, if you have a look at the facts, very strange situation. Award was passed by the arbitrator. It went before the single bench of the Delhi High Court. The single bench sustained the award in its entirety. The matter went before the division bench. The division bench set aside the award. The matter went before the Supreme Court. The Supreme Court brought back the decision of the single bench. And the award was sustained. The review was filed before Supreme Court. Review was dismissed. Then curative petition was filed before the Supreme Court in its curative jurisdiction. And in curative jurisdiction, the Supreme Court said that the award is bad. So many years of litigation, so many years of litigating before the arbitrator, single bench, division bench, Supreme Court, review in Supreme Court, all turned out to be infructuous because of the award being set aside. The reasons people allege in Delhi, in the corridors of power in Delhi, is because of the parties involved. There was something which went on. But then we are not concerned with that. We are concerned with the law which is laid out in this judgment. And I would request everybody to have a look at paragraphs 35 to 37 of this judgment as laying down the law as we understand it today. Paragraphs 35 to 37 of this judgment of 2024. All the judgments that are there on setting aside of arbitral awards, apart from these 3 judgments that we have discussed today, perhaps don't say anything different from what we have discussed. Subject to being corrected, I don't think there is anything else apart from what has been discussed today in deciding what the law is under section 34. The only change is something which came about, as I said right at the beginning, on 30th of April 2025, exactly a month ago, when another constitutional bench of the Supreme Court decided for the first time that awards can be modified by a court under section 34 by a majority decision of 4:1. And this is the judgment which I have sent in your note as Gayatri Barasamy. Judgment of Gayatri Barasamy. It is not yet reported in Supreme Court cases, but the SCC online is there. It is 2025 SCC online, Supreme Court 986. 2025 SCC online, Supreme Court 2025 SCC online SC 986. And in paragraph 85 of this judgment, the Supreme Court lays down the following guidelines for modification of an arbitral award. This becomes important because courts now exercising jurisdiction under section 34 can also modify an arbitral award in these circumstances which are now laid down in this judgment. What are the circumstances in which courts can modify? First is if the award is severable and the invalid portion can be separated from the valid portion. Now one finds in the statement of claims, separate claims are made on various grounds. The awards are passed separately for each of the claims. And then there is a paragraph which says in aggregate, therefore, I am awarding a sum of X, Y, and Z with interest at such and such. So if one finds that a particular claim which is invalid, either because it is opposed to public policy or it is vitiated by patent illegality, is liable to be set aside, a particular claim, that can be severed, and that portion of the award can be modified by setting aside only that portion and not setting aside the award in its entirety. So if the award is severable, the invalid portion can be severed by the section 34 code. Secondly this is actually something which is very helpful, because otherwise what happens is the court, being left with no alternative, has to perforce set aside the entire award, and the parties have to go back to adjudication all over again, de novo, from day one. So this, what happens is only the severed portion is again adjudicated upon, or if it's final, be it as it may. The second aspect is also very important. If there are clerical, computation or typographical errors, there was a provision already under section 33 of the Act, where a party could apply within 30 days of the passing of the arbitral award before the arbitrator for correction of clerical, computation or typographical errors. But what happened if this was not done? Or the arbitrator on his own did not notice these errors? This became part of the award and would create unnecessary confusion and lead to complete chaos. So this power is also there to correct clerical, computational or typographical errors which are apparent on the face of the record. Second is post-award interest may be modified. Now the law on interest is quite clear. The arbitrator has the power to award interest from the date of cause of action till the date of commencement of proceedings, which is pre-reference, from the date of commencement of proceedings till the date of the award, which is pendenti lieti, and date of the award till the date of payment, which is post-award interest. Now so far as pre-reference interest is concerned and the pendenti lieti interest is concerned, unless the interest rate is usurious or it is unconscionable and is held to be so with reasons, the arbitrator is bound to give at the contractual rate. But post-award interest is completely at the discretion of the arbitrator. And here sometimes the arbitrators are in giving rates of interest which were not in consonance with the prevailing rates. Earlier there was complete silence. Then at one point of time, the legislature thought it fit to make an amendment to section 31, subsection 7 with regard to interest. And now the position of law is that if the award is in completely discretionary, insofar as post-award interest is concerned, if it is silent, it is bank rate plus 2%. But if the award is not silent and the arbitrator gives something which is humongous, then the section 34 court can always interfere with post-award interest. And then of course there is a provision under Article 142 where the Supreme Court can intervene in other situations. But so far as we are concerned with the portions of the award which are invalid by reason of section 34, but those portions can be severed, they are severable, and therefore only the invalid portion can be cut like a cancerous arm and can be destroyed. The rest of the award being executable. Secondly is for correction of errors. And thirdly, post-award interest. This is as concise as I could possibly be with section 34. I must have left out a lot of it, but I'm sure you'll be happy that I left out the rest of it. Then we come to the one last provision which I feel is of importance, leaving out the other provisions, which is section 36. 36 is important because courts are now inundated with execution proceedings. Now, section 36 on the face of it is quite simple, that when the time for making an award has expired and that award has no application for setting aside has been made, the award becomes enforceable as if it were a decree of a civil court. What is the time for making an award? That is in section 34 subsection 3. Section 34 subsection 3 says 3 months plus 30 days. Now please note that in section 34 subsection 3, it does not use the word 90 days and 30 days. It says 3 months and 30 days. This is of some importance because 3 months may be very different from 90 days because different months have different number of days. And it's important because it says at the end of it, if you please see this, an application for setting aside may not be made after 3 months have elapsed from the date on which the party making that application. That's how section 34 subsection 3 starts. May not be made. It starts with a negative. And please see the proviso. This is of great importance. Provided that if the court is satisfied that an applicant was prevented by sufficient cause from making the application within the said period of 3 months, it may entertain the application within a further period of 30 days, but not thereafter. But not thereafter means that section 5 of the Limitation Act will not apply. 3 months, 30 days and you have missed the bus. Even 1 day more, section 5 condonation of delay cannot be done. So after 3 months and 30 days have expired, it becomes ripe for enforcement. So a party can apply under section 36 for enforcement. Now a party, the losing party, which has suffered the award, has made an application under section 34 within the time frame for setting aside the award. The law as it earlier stood was that the moment an application was filed under section 34 for selling the award, the arbitration award became comatose. It became a state of suspended animation and one could not enforce it. But now the law has changed. The law now says that very well you have filed an application for setting aside the award, but the award still remains executable unless you apply for stay by a separate application. And while applying for stay, the court has the discretion to ask you to put in money, like it would in a money decree. So the principles of Order 41 Rule 5 would come into operation, and one would need to secure the entire amount of the award. So it is not as if merely by filing an application under section 34, the party who has lost becomes free from all worries till the section 34 court disposes it of. And one does not know how long the courts would take to dispose of section 34 applications. And that would be district courts, high court, Supreme Court. Time immemorial almost. So because you've now put in money, and that you get in section 34, subsection 2 and subsection 3. And the proviso to that saying that in case of awards or payment of money, the application for grant of stay, the courts would have regard to provisions of the Code of Civil Procedure. And the provisions for stay of money awards are in Order 41 Rule 5. So you have to put in security. Security equivalent to the amount of the award. And now the Supreme Court says, giving further relief, that very well the defaulting party has put in security by way of the amount of the award, along with interest. the award holder can now withdraw that money from the court. This is not in the Act, but this is by judge-made law. The Supreme Court says that whatever money has been put in by way of security in the court in respect of the amount of the award plus interest, that money can now be withdrawn by the winning party by putting in an equivalent amount of bank guarantee. So the winner has money at its disposal. It is not as if it is out of pocket despite having got an award in its favor. So this is substantial relief to the award holder until the award can ultimately be executed. If the award is ultimately set aside, the security by way of bank guarantee is there. That will be invoked and given to the other party. But if he succeeds, he gets money from day one. If the party who has filed an application under section 34 says, no, I don't want to put in the money, I don't want to put in security, then the award will be executed. There is no stay. There is no automatic stay. To get a stay, one needs to apply by way of an application under section 36(2) and 36(3), and the proviso says that the provisions for security are equivalent to the provisions as contemplated under the Code of Civil Procedure, which says one has to put in security. So this is section 36, enforcement and protection of the rights of the award holders in enforcement. There is only one rider insofar as this is concerned, that if the court which is asking for security is satisfied that the arbitration agreement or the contract which is the basis of the award or the making of the award was vitiated by fraud or corruption, then automatic stay would be granted. This is the only exception. Otherwise, there is no other exception recognized in law which may save the loser in the award from putting in money as security. And this you will find in the proviso. It says, provided further, that where the court is satisfied that the prima facie case is made out, that the arbitration agreement or contract which is the basis of the award or the making of the award was induced or affected by fraud or corruption, it shall stay the award unconditionally. So, save and except this situation, in all other situations, the award holder now has ready money at its disposal. It only has to put in an equivalent amount of bank guarantee. The other protection that the Supreme Court has also made by way of judge-made law is that earlier on there was a provision in the Civil Procedure Code that in preferring appeals from money decrees, the state, in other words the government, whether it be the state government or the Union of India, does not need to provide security. This is a special provision in the Civil Procedure Code that the state government or the union government, in other words the state, does not need to secure the decree. The Supreme Court has held that insofar as awards are concerned, this will not be applicable. And even if it is the state government or the Union of India, or for that matter the railways, which are arms of the Union of India, everybody will have to put in security if they want a stay. So this is so far as section 36 is concerned, enforcement of an arbitral award. I think the learned director is wanting that we should now bring this to an amicable end.
Subject to...
And if there are any questions, I'll be happy to answer. I don't know whether I'll be able to help in assimilating or clarifying doubts. To the extent that I know, to the extent that in a very humble way, I've been trying to assimilate the law and take my own career and life forward. I've tried to put across to this audience. I'm so very grateful to all of you.
So, especially the learned principal district and judge is also here. Especially this issue being dealt by the district court of learned district judge of concerned district court. So, I request learned district judges if you have any query to clarify.
I have one query. I came across one of the case that arbitrator is one of the close friends of one of the parties. That fact came to know during the arbitration proceeding, and when the parties came before my court for setting aside the arbitration award, and during the course of hearing, they argue one of the point that although there are some other ground, though I arbitration award I have been set aside some other ground, but one of the ground that was the one of the ground under how to determine that there is no, I don't know, I don't find any record that they are actually trained, they are good trained, they are read together, all school, college, all these things. Both are engineers. One of the contracting engineer and another is also engineer, arbitrator. Subsequently, that engineer has an award against the friends. I don't know that how to decide.
Sir, if I may put it in this way, there's a famous poem by John Donne which says, "No man is an island, every man is part of the main." So it is impossible for people to not have friends. And I am a lawyer, they may be a former judge or another lawyer who is an arbitrator. We may be very close friends. Again, as an arbitrator, I may know the proprietor or the managing director or the chairman of one of the parties. But friendship and integrity are two different aspects. Now, so far as statute is concerned, it is the statutory mandate and duty of the arbitrator under section 12 to disclose from the time of his appointment and throughout till he makes the arbitral award all circumstances which may give rise to justifiable doubts with regard to his independence or impartiality. These are the exact words the legislature uses. Justifiable doubts with regard to independence or impartiality. It is his duty. So as a man of integrity, if I was very close with the litigant before me, I should disclose that. Now once I disclose it, it is up to the other party to take steps if he feels now this is something which may hurt my integrity and otherwise it may vitiate the award or compromise the integrity of the proceedings, to make an application under section 13 for my removal, saying that I am not independent or I am not impartial. That provision is there under section 13. Secondly, you will find that the legislature has now brought in two schedules, Schedule 5 and Schedule 7. If the disability falls within Schedule 7, it is an automatic disqualification. And that automatic disqualification, the party can raise under section 14 as I explained. But apart from the automatic disqualification under section 7, there are also larger number of grounds given in Schedule 5. If you have a look at Schedule 5, apart from the grounds given in Schedule 7, there are larger number of grounds given in Schedule 5. Now, what happens is, how does a party know that there are circumstances which may give rise to justifiable doubts with regard to his independence and impartiality? The legislature has thought it fit to give examples. So if you fall within these examples, then the court can, the party and the court can immediately find out that these are grounds which have given rise to justifiable doubts. Therefore, on these grounds, the arbitrator should have recused himself or his mandate should have been terminated. But being a friend is really too weak. You have to fall either in Schedule 5 to have doubts or Schedule 7 for it to be an automatic disqualification. Otherwise, if you look at section 12, you will find that section 12 itself starts with a statutory mandate giving an obligation on the arbitrator from the time of his appointment onwards to keep on disclosing all circumstances, whether directly or indirectly, all the circumstances, all his relationship with the parties and his interest. And the moment it comes to light, then the party has a period of 15 days within which he can make an application. But this 15 days is directive and not mandatory. So there is an option given to a party to apply before the arbitral tribunal that you please recuse yourself, you withdraw because we find that you may not be independent. But if a party has not taken that approach and has done nothing and has participated in the reference despite knowing the relationship, the court said in section 34, this should not be entertained. Unless it falls within Schedule 7, which is an automatic disqualification.